silent. The Honorable Judge of the Intermediate Court of Appeals, Chief Judge Charles O. Lawrence presiding. Oyez, oyez, oyez. Silence is not commanded under penalty of fine or imprisonment while the Honorable Judge of the Intermediate Court of Appeals are now sitting. Let all persons have motions to make and appeals to prosecute come forward, and you shall be heard. God save the state of West Virginia and this honorable court. Please be seated.
Having a bit of a sense of deja vu this morning. Good morning. Clerk will call the first case.
First on the Rule 20 docket, Consolidated Cases, Putnam County Aging Program, Inc. et al., v. West Virginia Healthcare Authority et al., numbers 24 ICA 98 and 24 ICA 99, an appeal from the West Virginia Healthcare Authority.
My predictions are always wrong, but you have 20 minutes and you can reserve, that's all you've got today. And you can reserve as much as you'd like for a response or reply if you'd like.
Thank you, Your Honor. I'd like to reserve 5 minutes for the rebuttal reply.
Very good. Please proceed.
Thank you, Your Honor. If it may please the court, Richard Walters and Ryan Walters from Schaefer & Schaefer here today on behalf of the petitioners, Putnam County Aging Program, Inc., Fayette Senior Programs, and Summers County Council on Aging. With me today is also Jenny Sutherland, Executive Director of Putnam County Aging Program. This appeal comes to the court on the hearing examiner's decision to grant summary judgment at a pre-hearing conference in the underlying CON matter. And I didn't misspeak there. This is not a board decision. This is the hearing examiner's decision to grant summary judgment. The granting of summary judgment on a record when there was no record. Now, any lawyer who steps foot into a courtroom or even goes to law school understands the basic principles of a motion for summary judgment. And that a motion for summary judgment is not appropriate unless there is no genuine issue of disputed material fact. Even the hearing examiner, in her decision on page designated record 1006 of 24 ICA 98, found that if the record, when reviewed most favorably to the non-moving party, discloses that there is no genuine issue of fact, then a motion for summary judgment is appropriate. On designated record 1007, she goes on to state, here, the record shows that no genuine issue of material fact exists and that Panhandle is entitled to judgment as a matter of law. The record considered by the hearing examiner. Fun fact, there was no record. So when the hearing examiner says that they reviewed the record, what they mean was they reviewed the arguments at a pre-hearing council, at a pre-hearing conference. And let me clarify something. I'm telling you there's no record, and I just referred to page 1006 of the record. So let me explain to you.
Administrative record.
Administrative record. And let me explain how that came about. The purpose of the pre-hearing conference can be found at 65 CSR 32, section 818, where it states that the parties shall exchange a list of all witnesses and copies of all documents to be presented at the public hearing. The witnesses' list and copies of documents shall be filed by the parties and with the authority. So on the morning of the hearing, we walk in and the attorneys proceed to hand the hearing examiner 3-ring binders full of thousands of pages of documents that are going to be used for the upcoming evidentiary hearing, as well as list of witnesses. The hearing examiner takes this record, which is a partial record developed only from the written discovery. Obviously, it does not include the testimony that's going to be elicited at the evidentiary hearing. The hearing examiner takes this record, sets it aside, takes a brief argument on the motion for summary judgment, never reviews the record, never reviews our response to the motion for summary judgment, and concludes that there is no fact in the universe that we can present, no argument that we can make that would change her mind that summary judgment is relevant in this matter. And no, I did not misspeak. Change her mind, not the board's mind, the hearing examiner's mind. She made the decision in this matter, despite the fact that she repeatedly told us she was not the decision maker. And as I'll get to in a minute, the law clearly states it's not the hearing examiner's position to make these decisions, it's the board. In essence, the hearing examiner found that there was not a conceivable fact, and even the healthcare authority argued on page 8 of their brief that the hearing examiner determined that there are no facts that petitioner could argue that would change the fact. So we have a record that wasn't considered. We have a decision from the hearing examiner saying that we can't present any evidence. And then in respondent Panhandle Sports Services brief on page 5, they state petitioner, even when directly questioned, could not state any material issues of disputed fact it hoped it could present at the hearing. Page 10, petitioner did not know what the facts were. And finally, in light of petitioner's incapability of stating a single genuine issue of material fact that could be disputed, shows the healthcare authority was not clearly wrong. And of course, when they're talking about the petitioner's argument, they're talking about my argument. So instead of just standing here and disputing what was argued and what wasn't argued in front of the hearing examiner, let me take a second and read to you what was argued. When the hearing examiner asked us to respond to the motion for summary judgment, and this is on designated record 982, my response was, quote, pursuant to 65 CSR 32, the Code of State Regulations 8.11, hearings and matters before this authority are conducted pursuant to the Administrative Proceedings Act, which is found at West Virginia Code 29A-5-1. In the Administrative Proceedings Act, the only reference to the West Virginia Rules of Civil Procedure is with regard to discovery and discovery disputes. Through both the Healthcare Authority's policies and procedures for conducting evidentiary hearings, as well as the Administrative Proceedings Act, there is no mechanism for a Rule 56 summary judgment. As such, the motion for summary judgment in and of itself is inappropriate. Even if the authority were to consider the motion above and beyond the fact that it's procedurally inappropriate, it clearly fails on its face. The premise of the motion for summary judgment is that there is no material facts. The facts in this matter have not yet been developed. The purpose of this proceeding is to hold an evidentiary hearing with testimony with witnesses. You cannot move for summary judgment before the facts have been developed, before the relevant facts have been presented to the authority. The main reason why it fails is we've not put on our case yet. There's evidentiary testimony. We have hearings set. We're scheduled testimony scheduled for Tuesday, Mr. Atkins' testimony, as well as this evidentiary hearing, which is scheduled. The documents haven't been reviewed, the testimony hasn't been collected, and our arguments haven't even been made. That was our response to the summary judgment. It wasn't that we couldn't stand up and articulate some type of dispute. In fact, I'll get into it. There were multiple disputes that we were able to articulate. They just weren't ones that the hearing examiner was inclined to entertain.
So, counsel, one of your arguments is that the HCA does not have the authority to grant summary judgment in an administrative hearing that's required under the section 16(2)(d)(13). Is that correct?
Absolutely. And absolutely, Your Honor. And there's two ways, or two reasons why this appeal needs to be vacated. One is summary judgment granted on no record. The second is, as the court just indicated, there's no authority for the hearing examiner to actually do this. By granting a motion for summary judgment, the hearing examiner violated West Virginia Code Section 16(2)(d)(15), West Virginia Code Section 29A-5-1, West Virginia Code 29A-5-2, West Virginia Code Section 16-29B-12, West Virginia Code Section 29A-5-3, and 65 CSR 32. And those are just the obvious ones. I'm sure with more digging, there are other code sections that were violated by the granting of this motion for summary judgment. And let me be a little bit more specific on why these code sections were violated. If you look at West Virginia Code Section 16-2-15, the authority shall render a final decision. The final decision with respect to a certificate of need shall be based solely on two issues. The authority's review conducted in accordance with the procedures and criteria in this article and the CON standards, and number two, the record established in the administrative hearing held with respect to the certificate of need. When the authority renders the final decision on a CON application, they are required to consider the full record as developed in the administrative hearing. West Virginia Code Section 29A-5-1, in any contested case, all parties shall be afforded an opportunity for a hearing. An opportunity shall be afforded to all parties to present evidence and argument with respect to the matters and issues involved, and the agency shall prepare an official record which shall, not may, which shall include reported testimony and exhibits in each contested case. West Virginia Code Section 16-29-12, Certificate of Need hearings. The board shall conduct such hearings upon a written demand by a person aggrieved, shall conduct such hearings. Section E, after any hearing, after due deliberation and in consideration of all the testimony, the evidence, and the total record made, the board shall render a decision in writing. The written decision shall accompany by findings of fact, conclusions of law as specified in 2953. That couldn't happen because there was no hearing, there was no findings of fact, there was no conclusions of law.
Are there any other purposes of the hearing other than recording testimony and accepting exhibits that can maybe be stipulated to otherwise?
Not that I'm aware of, Your Honor. If you look at Section 65 CSR 32, it sets forth why we're having this hearing. And it says the authority, and this is 8.11, the authority shall hold a public hearing on an application if it is requested within a time period. The authority shall conduct the public hearing in accordance with the requirements of the administrative hearings. And then it goes through and says, in that hearing, there'll be a date of the hearing, the pre-hearing conference, motions for discovery, not dispositive motions, motions for discovery, completion of discovery, and then subpoenas can be issued to make witnesses attend. Everything in the APA, everything in the CON, everything in the Healthcare Authority regulations is geared towards this evidentiary hearing. And the sole purpose of this evidentiary hearing is to collect the evidence, create the record for the board to consider on whether or not to approve or deny the CON.
Is there a process by which the Healthcare Authority can, other than maybe non-reviewability, can take actions by affected parties, admittedly affected parties, absent a hearing?
Meaning, can they rule on motions and things of that nature?
Right. I mean, you said you're basically saying there's no provision in the rule for dispositive motions. Are there? I mean, can the authority sua sponte do they? What kind of authority? And this is really a question of practice of the Healthcare Authority over the years. It's been in existence for a long time, and stuff evolves. Are you familiar with any other methods by which the Healthcare Authority can avoid essentially a full-blown hearing once an affected party appears?
I'm not aware of any way that they can absolutely avoid a hearing. They do have the means by which to address procedural matters. They can hear motions on procedural matters. Now, the respondents want to argue that a motion for summary judgment is procedural. I would argue it's pretty substantive. But nonetheless, the West Virginia Code, Section 29A-5-1, sets forth what they can do. So they can hear those procedural matters. They do have the ability to limit cumulative evidence. I mean, they do have control of the evidentiary hearing. So if they feel that there's hearsay, privileged information, they have the right to issue subpoenas. I mean, when it comes to discovery, they do get to follow the rules, West Virginia Rules of Civil Procedure. But there's nothing out there that indicates that following of the West Virginia Rules of Civil Procedure extends behind anything other than discovery. So to answer your question, Judge, I don't think that there's anything, once an affected party has requested that hearing, based upon the law that we've seen, that's the regs, that allows the Healthcare Authority to say, no, we're not going to do it. Or you can avoid that hearing for any legitimate reason that we're aware of.
Are you aware of any other agencies that have taken the position that they can avoid a hearing that's imposed by law and or rule by doing summary judgment in West Virginia? The only
ones, and they are, and the respondents cite a slew of federal agencies that do have the ability to issue summary judgments. And the huge distinction between the federal APA and any agencies that have the right to do the summary judgment, issue summary judgment, is clearly set forth, just like it is in Rule 56 of the West Virginia Rules of Civil Procedure. That process, if you're going to allow an agency to grant a summary judgment, you have to have the due process protections. You've got to say what it entails, what the court can consider, how's it can consider, what's your briefing schedule, is it going to be argued? And you've got to grant that right. And they do it in the federal APA. They do it in most of your federal agencies because those are being heard by administrative law judges. Those are the judges, just like in circuit court, judges sitting as triers of fact. The hearing examiner is not a trier of fact. That's the board. The hearing examiner's role is to collect the evidence and create the record for presentation to the board, not for decision. And by collecting that data, or by making the decision that there was no data out there that could possibly be collected, the hearing examiners usurped the authority of the board and improperly made the decision to grant the summary judgment in violation of each one of those code sections I just identified.
Are you aware of the authority ever granting a summary judgment in a CON proceeding before?
I am not, Your Honor. And the respondents acknowledge in their responsive pleadings that they also are not aware of any state law where this issue has been addressed. And I'd represent to the court because if the healthcare authority had granted a summary judgment, it would have gone to the Supreme Court and we would have law on it. I'm not aware of it ever happening other than this case in front of us here today.
If you want to preserve your 5 minutes in response, then I think it better wrap it up.
Okay. I'll go ahead and break then and save the remainder for the rebuttal.
Thank you
Your
so
Honor.
much. In light of the fact that I didn't get direction from counsel, the respondents will split their time 10 and 10, if that's okay, equally, and I'll ask the Healthcare Authority to talk first. Counsel, you're ready to go.
Thank you, Your Honor. Good morning and may it please the court. My name is Caleb Seckman on behalf of the authority. Now, as is obvious to everyone, I'm sure this case is largely a companion to the ones you heard yesterday, and so there's a lot of overlap. The obvious difference.
We don't need any of the overlap.
Correct. The obvious difference is the summary judgment here. So with my time, I'm going to focus on two things about that. First, I want to explain why summary judgment is a legitimate agency procedure in general, and second, why the summary judgment grant here was correct. So starting with the lawfulness of summary judgment procedure generally, West Virginia's APA gives three powers that include summary judgment. It specifically gives agencies the power to dispose of procedural matters, regulate the course of hearings, and take actions as authorized by its rules. Summary judgment fits into each of those. It, of course, regulates hearings. As we explained, it is a procedural matter, and the authority does, in fact, have a rule enabling hearing examiners to decide motions. That's Code 6532.8.17. And on top of that,
Could you repeat that?
6532.8.17, 8.17.
Okay, it's Code of State Regulations. You said
Yes,
the code.
sorry.
I'm
Oh, I
sorry.
apologize. Yes,
My bad.
Code of State
No
Regulations.
worries.
And on top of that, the APA, West Virginia's APA largely tracks the federal APA. It specifically does so here with those three provisions, that's the contested case language. So as the Supreme Court of Appeals has said over and over again, we should interpret those provisions consistently with the federal ones. And across the board, in cases applying the federal APA, even as petitioner you heard said, there's a slew of federal agencies. We see administrative summary judgment regarded not just as something they can do, but as settled practice. Indeed, most federal agencies use it, and it seems that there's a near consensus on the issue to the point where the U.S. Supreme Court has affirmed cases using such procedures.
Has any West Virginia agency utilized it when it's specifically stated in the law that that you have to have a hearing?
So, Your Honor, two things. We're not aware of any other agency using it, but we do think that even where it says you have a hearing, there are federal agencies that would say the same thing, and the summary judgment motions are able to overcome that, and we think that is the case here.
But you don't have any support from the Supreme Court to justify that position?
To your question, we agree with
West Virginia Supreme Court?
Correct. No, petitioners are correct that the issue doesn't seem to have come before any court so far.
Well, the language that requires a hearing is pretty clear. Would you agree with that, both in the statute and the regs? It says if somebody asks for a hearing, you shall have a hearing. That's not ambiguous, is it?
That's not ambiguous, Your Honor. Correct.
And wouldn't you agree with me that you're trying to extrapolate from words, but you can do motions, you can do procedural stuff. I mean, those you have to admit are somewhat ambiguous. If you're arguing that there's power to hear dispositive motions out of that language, that at best is an argument from ambiguity, isn't it?
We don't think so, Your Honor. Motions.
Okay, tell me a statute or regulation that specifically says you have the power to do dispositive motions. Not just motions, tell me the statute or regulation that clearly, absolutely says you have the power to do that.
Your Honor, none of them say dispositive motions, but we'd argue that motions is clear. It doesn't limit it to non-dispositive motions. I think that would be clear in the other direction. Here, just saying motions would include all motions.
The rules of civil procedure are pretty clear when they talk about dispositive motions compared to other motions, aren't they?
I think so, Your Honor, but if you say you can consider, this is going to sound silly, but you can consider dogs. You would assume all breeds. If there is a limiter on that, the limiter would be more specific. But if you take away a limiter, the language is still specific, it's just broad. And that's what we have here. And there's good reasons for that.
Is that language in code or just in the Administrative Protection or the Administrative Procedure Act?
So the power to consider motions is from the code. The Administrative Procedure Act grants agencies the power to take actions as authorized by their rules.
So you're basically arguing that, I mean, in order to get rid of, as Judge Greer said, you have to argue that it's ambiguous as whether a hearing has to occur in order for your argument to be correct. Is that not correct? Because it specifically states a hearing has to occur.
We think that a hearing has to occur, but there are other things that interact with that, and that's these agency procedures, disposing of matters, regulating the course of the hearings. So there's interaction there. Of course, the baseline is yes, hearing, but then it does have these other things that go along with that, which can make it so that a hearing is unnecessary. And there's good reasons for this, as federal courts have said. There's no due process requirement that an agency hold an evidentiary hearing or waste time when the record as it stands conclusively shows the case can only go one way. So just like any summary judgment case, if there's no material issue of fact and you can decide it on the law, there's nothing else to do.
If this authority's been there all along, why has no agency in the history of West Virginia ever done this?
I can't speak to that, Your Honor. All we know is that the language here would have allowed it. It just seems that they've not.
Nobody's thought of it before now?
I suppose not, Your Honor, but we contend that they could have.
Let's turn to the second issue. Oh, sorry if you got
Go ahead,
another.
go ahead.
Let's turn to the second issue, which is whether the administrative law judge in this case, the hearing examiner, excuse me, in this case, had the authority to bind the board by signing a document called dismissal order.
So I want to actually.
Is there an authority that's been granted? Are we unaware of a document that shows a chain of authority that's been delegated?
So I want to kind of correct something in your premise there, Your Honor. With respect, the board still made the decision here. The hearing examiner is the one who made this summary judgment, but these cases still go before the board after that. They still have to sign off on it. And it appears that that's not in the record, but we're happy to supplement here. But there was a certificate of need granted by the board following these summary judgments. So all the hearing examiner did was issue the summary judgment motion, close evidence, say this is what I think should happen. Sorry.
So you're asking us to consider something that's not in the record?
You don't need to consider it outside the record, Your Honor, because it appears that they just appealed the wrong thing, potentially. Here, the summary judgment motion was granted, but afterwards, the certificate of need was also granted formally by the board. And that certificate of need still is on their own decision.
This disposed of the entire claim of the affected party, is that correct?
Correct. It disposed of their claim.
So,
They were no longer affected parties to object once they're kicked out. They wouldn't have standing to object to the certificate of need because they're already out of the case.
And that certificate of need, though, Your Honor, is still issued by the board. So the point that I'm trying to make is just that the hearing examiner closed evidence, issued summary judgment on, as you're saying, the affected party. But the board still independently reviews it, looks at everything, makes sure all the factors are met, and
But
grants.
when there's no affected party complaining about it anymore.
There's still affirmative showings that need to be made by applicants, Your Honor.
Oh, I know that, but they're not there to contest it anymore. I mean, the board did not make the decision on whether they were gone or not. The hearing examiner did that. The board made the decision on whether to issue the certificate of need after the affected party was gone. That's totally different than saying the board weighed in on the decision of whether they're gone or not.
Well, the authority could have said it was improper to dismiss them. We're still going to consider this, and it did consider everything before it. So it is still looking at, is there unmet need? Does it significantly limit services?
without the claim and argument of the affected party who was dismissed in this order. I mean, if we're analogize it to a civil action, once a party is dismissed and not subsequent order is issued, the dismissal of a claim, at least 54B, you have a right to it. It's not interlocutory, and I don't know what the findings were by the board. I mean, in this case, clearly, when it was brought and by the notice of appeal and then the petitioner's brief, you all had noticed that if there was another order that needed to be considered by this court, which was not brought by this court, I mean, you're in control of that. We could have gotten it. We don't have it in front of us. What we have is the pure legal issue, really two. One is whether the agency itself, the healthcare authority, as a body, had the authority to issue without hearing an order disposing of a claim by an admittedly affected person. And they were entitled by statute to a hearing, and they didn't get one because we found that all the 2 pages of decision, of analysis by the hearing examiner were stated. There now appears to be a separate order a decision by the healthcare authority also disposing of the same issues and dealing with the arguments that would have been presented at a hearing?
So, Your Honor, the order from the authority is the decision whether to grant the certificate of need. They've appealed the decision of the summary judgment which disposed of their claims. So my point that I'm trying to make, I guess, is that the summary judgment grant is not what granted a certificate of need. All the summary judgment grant did was dispose of their arguments. The board then still does independently review whether the certificate of need is satisfied. So they can challenge the summary judgment, but the hearing examiner is not the one who actually herself granted the certificate.
So are you saying that the board does have to grant the certificate of need? That you're clearly saying that, but are you also saying that they don't have to review the hearing examiner's finding of summary judgment, and that they can just accept that without also ruling on that issue?
Your Honor, they get the record as the hearing examiner presents it, and it goes to them, and they make their decision based on that.
Yeah, we are out of time for you, and we're going to need to keep things moving. So if you have anything else you'd like to say before your colleague steps up, let me know.
Yes, I would just like to finish by saying that they argue there's no record. They did make a record here. Discovery was closed, and they simply lost on the legal arguments. You heard yesterday they said that if the need methodology was proper, unmet need would be shown. We argue that this case again hinges on the need methodology, which was proper and was satisfied.
Thank you.
Thank you.
We say that wasn't Atkins' deposition scheduled after this hearing?
It was, Your Honor, but
And everybody knew that?
it was, Your Honor.
How was the record complete if you knew there was another deposition that was scheduled that was going to complete the I mean, that hadn't been done yet. Nobody knew what he had said. How is the record complete?
So a record can always get bigger, Your Honor, but there was enough here to look at. Discovery was closed. There was enough here to say the certificate of need, the methodology is satisfied, and this will not significantly limit other services.
Discovery was closed, and yet there was a deposition scheduled. It doesn't sound like Discovery was closed.
Well, sorry, we were past the deadline of discovery. This hearing was just to get more testimony from Adkins. You can't defeat a summary judgment motion by just saying, well, we want more facts. We got to keep getting more facts.
But I think any circuit judge is going to say when there's more depositions scheduled, they're not going to rule on the summary judgment motion because they know there's more discovery scheduled, and discovery's not closed.
With all due respect, Your Honor, I think if you had a case before you there where a bunch of depositions came up, but it became clear that on the law there was nothing that they would change, I think a judge would be able to rule
So you're
on
telling
summary
me there's
judgment.
nothing possible that I'm sorry, I don't remember Atkins' first name.
Timothy.
And I apologize for calling him Atkins, but you're telling me there's nothing possibly that Atkins could have said that would have changed this whatsoever. He could have said anything in the world and it would have had no effect.
That's correct, Your Honor. The need methodology was satisfied, and there was no way for them to show that other services were significantly limited.
He could have said that I pulled this need methodology out of thin air. There's no basis for it whatsoever. I rolled the dice and it came up 3, so I came up with 3%, and that would not have changed anything.
To be clear, they weren't challenging the need methodology based on its own merits at that point. They were only challenging whether it was shown satisfied here.
Okay.
Thank you.
Good morning.
Good morning.
I'm Brock Malcolm, Bowles Rice, and I represent the respondent, Panhandle Support Services. I'm joined today by Evan Worrell, who runs the West Virginia operations for Panhandle. I guess I would kind of jump in and try to answer your questions, Judge. I think that there was a hearing. There were 2 hearings. There's a trial hearing, and then there's the trial itself. And we go back to the APA, and it says very clearly that the agency shall adopt procedural rules for the handling of contested cases. And it's adopted the West Virginia Rules of Civil Procedure. You look at Rule 1.
Where does it do that?
The Healthcare Authority has adopted in total the rules of
For
civil-
process of these hearings, I think that's absolutely the case. I mean, there's no.
Where is that? Where is that? I mean, tell me the regulation, the statute, give me the document where they incorporated the rules.
I
of
don't know
civil
that it's officially in any document, but I mean, as a practice point, as somebody who's all the time in front of the Healthcare Authority, these hearings are conducted in accordance with the rules. We make our arguments based on the rules. We handle evidentiary matters in accordance with the rules of civil procedure. You mentioned before about had anybody ever filed a motion for summary judgment? I have. I've lost them on the basis that there was a determination that there was an issue of material fact, but there has been consideration of these motions in the past. This is not a one-off. So the practice of that agency is to follow those rules when we are litigating these cases. They're essentially little trials. And so when we got the scheduling order, it was very clearly set for the filing of dispositive motions. There was a date set on which we had to file those and a date set on which we would hear those. Everybody had notice of that. There was no question. This wasn't out of left field. Nobody was should have been surprised that there was a dispositive motion in a case like this. What Rule 1 says essentially is that these rules are meant to govern the efficiency of all cases and to assure a just, speedy, and inexpensive resolution of issues. It's
And whose
that the
convenience is
exceptions to that are Rule
Whose
81.
convenience is that for?
Well, I think it's for all the parties. I think in this case, we argued that if you take the 2023 standards that were signed by the governor and effectively made into law, if you take those as valid, then the need was established for the counties, and we filed based upon those.
Yesterday, attorneys that represented similarly situated providers of personal care that were applying under the new standards argued that the standards created effectively a rebuttable presumption, but that there were certainly, there could have been evidence provided at a hearing that would have overcome that rebuttable presumption insofar as establishing a need. Need was independent. I'm not saying what we've decided, but it was argued by folks in your same kind of position that indeed the rules were creating the need standard didn't foreclose a factual determination by the healthcare authority. Was that just wrong?
Well, I would disagree with it personally. But even if it is rebuttable, there has to be evidence to rebut it. And so we went through the discovery process. The discovery process closed. There's no question it closed. There was a clear date upon which discovery closed. Now, in addressing your point with regard to Mr. Atkins, that deposition was set up by all the parties, me included at the time, as a courtesy. He was going to subpoena him to every case. The authority was prepared to object to that.
So why didn't you wait until after the deposition in order to do your motion for summary
Because
judgment?
my hearing was set before.
Then why didn't you ask for a continuance? until
Because
after?
in my opinion, nothing he said was going to matter. Because ultimately, that attack of the standard is outside the purview of the hearing. The hearing is based upon the application before the tribunal. And if you want to take an attack on the the promulgation, I don't think that the hearing in front of the authority is the appropriate means for doing that.
And of
I think-
course, the Circuit Court of Kanawha County disagreed with you when they dismissed the frontal
Well,
attack, saying you had to exist.
with all due respect, they dismissed that action based on his failure to timely give notice to the state agency. There was no determination in that case at all as to the merits of the other arguments. It was strictly a procedural matter. So he could have refiled that and attacked that in the circuit court, and I believe that's where the appropriate attack on the promulgation belongs. So the healthcare authority determining already at previous hearings that they were not going to take up that issue and were not going to consider the issue of other services outside the purview of the healthcare authority, there really were no material issues of fact left to be decided here. Because they questioned directly by the hearing examiner, what else do you have to offer? The answer was, we don't know yet. This hearing was not a trial, it was a fishing expedition in hopes that they could find something to bolster their case.
Counsel, are you aware of any other administrative agencies that have adopted the civil rules of procedure without putting it in writing through either legislative rules or even an emergency rule or anything like that?
I'm not. It's just the practice that's there. I mean, it's been
Are you aware of
informal adoption.
Is there any case law that has approved this practice by the West Virginia Supreme Court?
I don't know that anyone has ever received summary judgment before, and therefore there's never been appeal. When I lost my summary judgment argument, we tried it, and all the same arguments resulted in me winning, so there was no appeal. The answer to your question is no. I'm not aware of any precedent.
I mean, I'm just
But-
talking about not even just summary judgment. I'm just talking about, you're arguing that the healthcare authority has the inherent authority to by proclamation, declare that the rules of civil procedure are.
I have had other cases in which affected parties did not appear, and those cases were dismissed for failure to appear. There was not a mandatory hearing held just because somebody had been awarded the right to have a hearing.
Well, but the statute kind of indicates that if there's no affected person, you don't have to have a hearing, does it not? So if they don't appear, then there's no affected person. So that is within the statute.
I think that the rule suggests that they have to do something to prosecute their case. They have to present some evidence. You can't just waste everyone's time and drag out these hearings just to cause applicants to have the time and expense of it. And so a retreading of Ms. Sutherland's arguments about the Meals on Wheels and transportation programs wasn't going to affect any change in this process. They'd subpoenaed no witnesses. So the idea that they were going to create some sort of record by cross-examining or interrogating witnesses from Panhandle, there weren't any. There weren't going to be any. So the evidence was clear in what was going to be.
How do you know there weren't going to be any?
Because they hadn't subpoenaed any, and I wasn't going to bring them voluntarily.
I mean, they could have brought witnesses, right?
Well,
They're
they could have. And they also could have attached affidavits to their response to the motion for summary judgment if there was clear evidence. And that's the proper procedure for this. It's not to come back after the fact and argue, well, we would have argued. You have an obligation. The rule specifically says, if the rule applies, the rule specifically says you have to counter the motion with evidence,
And I think
including
their point-
affidavits.
I think their point is they didn't because they don't think this is a legitimate procedure because nothing authorizes this, other than the silent adoption of the rules of civil
Well,
procedure.
I believe that they took that position. I mean, they came, they hand-delivered their response and hadn't really prepared anything other than, you can't do this. However,
Well, I guess that gets us back to the question. Tell me why the authority has the ability to do this other than the silent adoption of the rules of civil procedure.
well, the rules that apply, the APA says that they will adopt procedures for the handling of contested matters.
Can you tell me procedure that they adopted that says they can do dispositive motions?
No, I specifically, other than the basic adoption of the rules of civil procedure, which are followed throughout the process of the hearing, the pre-hearing, if you have a discovery issue, we follow the rules of civil procedure. And the idea that there was more discovery to be done, there was a clear closing date. There was no motion to extend it. There was no objection to the discovery that had been presented.
Was Atkins' deposition specifically designated as that's not discovery?
Yes, it was done as an effort to get Mr. Walters what he needed for a collateral attack on the 23 standards. And rather than dragging that into 6 or 8 hearings, everybody agreed that they would go ahead and create that separately. And there's no prejudice by not having him in this case because of that. The only one that was prejudiced is my client because we didn't have an opportunity to question Mr. Atkins. Otherwise, the record still exists. And if they want to take that matter up with the circuit court and attack that, that record exists, and there was no detriment to Panhandle not being a party to that.
Counsel, did the healthcare authority promulgate rules with regard to certificate of need?
Did the healthcare authority?
Correct. Legislative rules. Did they promulgate legislative rules with regard to certificate of need?
Well, I think the legislature promulgates those, and then they carry
No,
those out.
the administrative agency promulgates the rules and the legislature approves of the rules. Did the healthcare authority do that?
I'm not aware that there's anything that officially
There is.
accepts
It's Series
the.
7, it's 6571 at SAC. So I just, if.
Oh, I'm sorry, I misunderstood your question. Yes,
if-
okay, obviously the rural state code.
So why would the healthcare authority not put in those rules that they're utilizing the rules of civil procedure? If they had done that, I can see why there's an argument and why there would be why we would go against the clear legislative mandate that a hearing be held. But why would they not put that in there if they thought that the rules of civil procedure should apply to all of these hearings?
Well, Judge, I think the answer to your question is that those rules specifically discuss rules of procedure, not the West Virginia rules of civil procedure, but that's because the West Virginia rules of civil procedure already state that they apply to all these hearings. I mean, those rules.
Where do they
themselves-
state that they apply to all these hearings?
Well, Rule 1 says that they apply to any courts of record that, in all actions, suits, and other,
Are you saying that you're taking that to be all administrative proceedings in West Virginia?
well,
fall under-
that alone I would say is an extrapolation, except that they say that all matters except for those accepted by Rule 81, and if you go to Rule 81, it says that they apply to administrative hearings.
No, they apply to the review of administrative hearings. They do not apply to administrative hearings. They apply to circuit court review of administrative hearings. That's what they say. That 81 says.
Yeah, I understand what your point is, but I guess my point is, it doesn't make any sense to adopt rules outside of the rules of civil procedure for civil proceedings. We operate these hearings like a circuit court trial. And so to operate under any rules other than the rules of civil procedure would be silly. And so it's just the way it's done there. And it's understood by everyone who goes in there typically that you're going to have to meet that threshold if you want to proceed. And given the fact that they weren't able to offer anything that the court, the hearing examiner had said was a material issue of fact that was relevant to the application, which is really what this hearing is about the application. It's not about whether or not enough public hearings were held. It's not about whether or not their comments were considered properly. Those were addressed to the governor and he signed it in. And that's now the standard that was met by the application. All that other stuff is outside. And when you take that and you consider the hearing for what it's supposed to be, it's not a circus. It's a procedural matter on an application. There were no issues that could be raised that hadn't been decided by the authority, and therefore there was no reason to waste the time and
We
expense of the hearing.
We need to keep moving.
Okay.
Appreciate your time. Thank you.
Thank you.
We'll give you, we're not going to give you a whole bunch of extra time if that's okay. We need to keep the docket moving this morning. We had 5 minutes. You did reserve, and I'm going to give you your 5 minutes, and we're going
I
to stop.
understand, Your Honor. I think the record is clear in this matter. Just a couple real quick things, and I'll keep it brief. The concept that discovery was closed is absolutely ludicrous. What the scheduling order says is that motions for discovery, what the CSR, and Judge White, I think you kind of hit the nail on the head there. They have CSRs that say, here's how we're going to do it. Those CSRs say, yes, you can file motions. And in 18.3D, right above it, the last date to file motions for discovery. They're referring to discovery motions. The only references to the APA, to the CSRs regarding the rules of civil procedure are discovery. When you hear arguments saying we always follow the rules of civil procedure, that's because this is an entire discovery proceeding. So all the discovery that's being done is being done pursuant to the rules of civil procedure for the discovery purposes, not for dispositive motions, not for motions for summary judgment, for subpoenas, for testimony. Discovery was complete. If you look at DR 178, discovery was complete on before September 21. That was written discovery. There's a date, September 1, when you have to file your discovery request by, and a date when they have to complete it, the 21st. And underneath that discovery, it lays out, when you do these documents, if you're going to use them as exhibits, you have to bring 2 copies to the pre-hearing conference. It's discussing written discovery, not oral testimony. They cannot stand up here and testify as to what our evidence was going to be. There was an affected party I represent, Summers County Council on Aging. Their executive director was going to testify. She did not testify in this matter. During the underlying hearing, Mr. Lively, who represented that agency, raised issues with the petition or the application itself, saying the application had material misrepresentations. They represented they had the authority to operate in Summers County, and their contract said they didn't. These were issues that were raised separate from anything else that was heard in any of these other hearings. None of this was given a due course. None of these issues were addressed. To sit here and say that they knew what our arguments were going to be, they knew what the evidence was going to be, the whole purpose of the hearing is to take this testimony. And no, there was no agreement that Mr. Atkins' testimony was designated as non-discovery. The agreement was we were going to take his testimony and use it for all the cases. Not that it was somehow not discovery. It's exactly what it is. A deposition is discovery. Ms. Sutherland's testimony was discovery. Ms. Garrett's testimony would have been discovery. Mr. Worrell was on their witness list. They can now conveniently say we weren't going to call him, but at the pre-hearing conference, they submitted a witness list. His name was on it as an individual who's going to testify at that hearing. And I think, again, Judge Greer hit it on the nail on the head when you said if Mr. Atkins got up there and said, I rolled the dice and a 3 came up, that absolutely is evidence that the hearing commission or the board should take in consideration in determining whether or not the unmet need required by state law was met.
Mr. Walters, there was a dispositive motion deadline in the scheduling order, is that correct?
Yes, there was, in the scheduling order. It's not mentioned in the CSRs, it's not mentioned in the APA, it's not mentioned in state code. And specifically in the CSR, when they talk about motions, they talk specifically about discovery motions. In the state code, when they talk about motions, they talk about procedural matters. The mention of a dispositive motion is nowhere, it just shows up on their scheduling order. There's no authority at all in any of these enabling statutes, and there's nothing out there. And I'll make it very clear for the record. There's not a single piece of paper out there that indicates that the Healthcare Authority has adopted in full the West Virginia Rules of Civil Procedure. And as Judge White indicated, Rule 81 is not that rule. 81 has to do with the review of administrative agencies. It does not in any way grant authority for the Healthcare Authority to say, yeah, we're using the Rules of Civil Procedure. And outside that authority, don't forget, there was no record. How can you have a motion for summary judgment when there is no record, whether they have the authority for it or not? For those reasons, the petitioners respectfully request that this matter be vacated, remanded, and set for a hearing in front of an unbiased hearing examiner for further development.
We understand your case. It'll be submitted, and you all feel free to, we're going to stay seated here, but we're going to come see you, and then we'll remain seated. You guys can check out. Council will call the next case.
Next on the Rule 20 docket, Jason Wilhelm and Crystal Wilhelm v. Tunnel Ridge LLC, number 24 ICA 118, an appeal from the Circuit Court of Ohio County.
Council, you may approach and start your argument.
I would like to reserve 5 minutes for rebuttal, if I may,
minutes.
Your Honor. May it please the court, my name is Jamie Bordas. I'm the managing partner of the law firm of Bordas and Wheeling. It's always a pleasure to be here, and good to see you all. Judge White, congratulations on your new election to the bench and being here. First time in front of you. With respect to this case, we are asking this court to reverse the ruling of the court below, dismissing this case on statute of limitations grounds. I think it's important that we start with the purpose of statute of limitations. The purpose of a statute of limitations, of course, is to provide potential defendants in lawsuits that there may be an action brought against them, and that they receive notice that there may be an action brought against them within some reasonable period of time is the normal reason that a statute of limitations exists. Here, with respect to this case, it's important to note that the legislature enacted this code section for good reason. There's a reason that they addressed underground mining separate and apart from normal property damage that may occur to someone. And the reason for that is that we can't see what's going on underneath the surface as property owners here in West Virginia, or anywhere for that matter. You don't know what's going on underneath the surface. And the damages from mining, subsidence, may take a period of time, long period of time. And even after you first discover that there's damage being done, additional damages may manifest themselves because the ground continues to move, things can shift under the ground, and so it would be unfair to citizens of West Virginia to have to bear that loss when it was caused by someone else. So when there is damage done, this statute provides that that damage is to be paid for or fixed by the mining operator. Now, there was no tort alleged in the complaint that was filed here by the plaintiffs, and I think that's important. That complaint, I would encourage you all to take a look at if you haven't. That's found in the Joint Appendix 14 through 19. No tort was alleged, and going back even to my law school days, and of course I've filed tort actions for the last 25 years. I've filed them, primarily what I do. You allege a duty, breach, causation, damages. You'll see in the complaint those things are not alleged, and for good reason. A tort was not being pled here, and the reason for that is that our Supreme Court, just in 2018, in McElroy versus Shaney, had made it clear that an action of this nature is not grounded in tort. In fact, no negligence need be proven, and nor you even need to even prove a violation of the reg. That's 240 West Virginia 475. That's a Supreme Court case here in West Virginia. So there was no tort pled, and for good reason. This is a statutory cause of action. It's also important to note that our Supreme Court has said, including in Cochran versus Appalachian Power in 1978, that if a complaint could be construed as either a tort or contract, then it will be presumed as being in contract, and a tort statute of limitations would not apply. That was Cochran versus Appalachian Power. It's also important to note, Your Honors, that neither the West Virginia Act nor the Federal Act contain any time limits for bringing actions. And again, that's for good reason.
Counsel, what about 22-116? Is that not applicable?
I don't believe it is, Your Honor.
What?
And are you referring to the general property damage statute of limitations?
No, 22-116 is in the chapter which the Surface Coal Mining Reclamation Act is contained in. It's the general, it's the chapter with regard to DEP, and I'll read you the statute. I think we sent some sort of judge order asking for to address this. It says, notwithstanding any provision of the code to the contrary, no action, suit, or proceeding for the administrative, civil, or criminal enforcement of any provision of this chapter may be entertained unless commenced within 3 years from the date the right to bring the
That with respect to this, it's referring to primarily suits or proceedings for the recovery of any fine, penalty, forfeiture, pecuniary, or otherwise. I think that this particular thing is more related to the Department of Environmental Protection and what they may do with respect to that. So I think there's a difference there because of that. So that would be my thought on that. But I got to be honest, I haven't given that a lot of thought. But I do think that would be different because of the nature of what it's pertaining to. I think it's also important to note here that the Department of the Interior has interpreted the Pennsylvania Act. And that's important because, as we know, the state statute cannot be more restrictive than its federal counterpart. And that has been addressed by the Department of Interior, who has said that a statute of limitations on an action of this nature would not be appropriate because there's no such time limit in the federal counterpart. So I think that's important to note as well. But I think here's maybe the biggest thing. The appellee would ask this court and ask the court below to basically treat this claim as you would any old property damage tort claim. And realistically, it would render the need for this mining act moot if it was just the same as a regular old property damage action. And what I mean by that is this. Anytime someone damages your property, you could sue them for damaging your property.
But you wouldn't have the presumption without this act, right?
That's correct. You would not have that, Your Honor. And also, though, there were some distinctions made with respect to it in terms of one of them being that you don't have to prove negligence. And our court has said that, our Supreme Court has said that. And because you don't have to prove that negligence that you would have to prove in an ordinary property action, then it's clear that the statute of limitations for an ordinary property tort action do not apply here. That's one of the distinctions that was made.
Well, 55-212, though, doesn't talk about a tort action. It says any personal action. Is this a personal action? Even though it's statutory, I agree with you. I think it's a statutory cause of action, but is that not a personal action?
I don't, is this a personal action? I don't believe that it is in the way that that's described there. I don't know that personal action is defined. But I do know that no court that we've been able to find in the entire country has applied the tort statute of limitations to an action such as this. And in fact, as I said, the Department of Interior has determined that Pennsylvania's similar act would not be able to provide such a statute of limitations. So I don't think this qualifies as a personal action as is described in that code section, Your Honor. And I think also that it's, our basic argument boils down to this, that there is no statute of limitations for an act of this nature. And second of all, there's certainly not a 2-year one for tort. If anything, if there would be determined to be a statute of limitations at all, then it would be a 5-year statute such as is in place for an implied contract created by statute.
What's the contract here? What's the implied?
It's an implied contract.
What's the implied contract?
The implied contract is this, that if you, the statute is the contract, that it's created by the legislature between a company that's doing mining work and that property owner. And that's one of the reasons, Your Honor, I think it's important to note here, and that's reflected in the joint appendix, that this mining company went out to my client's home before they even started their mining. They went out there before they even started and did a pre-mining inspection so they could see what type of condition the house was in before they started. And mind you, this was a brand new built home. It was only 5 years old. I mean, this was this is a big deal to my clients to build a home.
What consideration are the property owners giving for this implied contract?
Well, what consideration they're being given is, I think, being
What are they giving up?
sure. They are the legislature was more properly equipped, I think, to determine that than us, because that's a contractual right. But what they are giving up is a number of things in terms of their ability to stop the mining from going on under their home.
Well, they're not giving it up. They don't have that ability.
Well-
It's not something they give up, they don't have it.
Yeah, but that's, our legislature has made a determination that it's gonna allow mining in this state and allow property to go under people's property and to do harm to their property. And this is the scheme that they're gonna establish. And these are the rights. The legislature has defined the rights of the parties, just as you would in a contract. Hey, when they go under there, here's what happens. In return, here's what you get. And whether that's a wise system or not a wise system, that's not for me to decide, really. But in terms of, that's the legislative scheme that was created by our legislature, is that these are your rights, just as if you had a contract with these people. Your rights are that once they come and do this, you have the rights to have this repaired, you have the right, or to be paid for it. Those are the rights that are created, and that is an implied contract created by statute. I also want to spend a few moments here on the estoppel issue. I think it's important to note that this case was filed previously in federal court. It was dismissed because of a procedural technicality, basically. And I'll describe that because I'm not sure that's real clear in the briefing. So this defendant is an LLC. The members of that LLC were a number of other either people or entities, and one entity was another at least one another entity was another LLC. This defendant that we sued was an out-of-state LLC. Therefore, we filed it in federal court. However, as it turns out, one of the members of that LLC, of this defendant, was another out-of-state LLC, but that other out-of-state LLC had one of its members who happened to be a West Virginia citizen. So maybe three links removed down the chain. A motion was filed in the federal court to dismiss the claim because of a lack of complete diversity. We realized once we read that, we had no reason to dispute that. We had no way to know it beforehand, but we had no way to dispute it afterwards, because the members of an LLC aren't necessarily always known. Sometimes just the organizing member is known, et cetera. So even if we could have looked it up, it would have been 3 chains removed, and it wouldn't necessarily have even stated who all the members were. But with that being said, once they set that forth, we had no solid grounds, and we didn't believe it would be appropriate to file some type of frivolous response. So we said, okay, we'll dismiss it without prejudice. And right in that document, which is part of the joint appendix, it says this complaint will be refiled. This is being dismissed without prejudice, and the complaint will be refiled. So there was no surprise. We look at equitable estoppel here. They knew about this. It said it was going to be refiled. They knew it was going to be refiled. And then, perhaps more importantly, in addition to the equitable estoppel arguments, are also that there's tolling estoppel arguments here as well. During the interim of when the case was dismissed in federal court and refiled in circuit court in West Virginia, there were significant negotiations that went on between the parties. If the defendant thought the statute of limitations existed and or had passed, those negotiations would not have continued. There would have been no reason for them to continue engaging in negotiations.
Do you have any authority that continuing negotiations toll the statute of limitations absent some agreement? Now, I'm aware of cases where parties have agreed, hey, we're going to have settlement negotiations and toll the statute for a while, but in the absence of that agreement, are you aware of any authority that the negotiations tolls the statute?
I don't know. I'm aware of a particular case, and to be quite frank, in hindsight, even though I wasn't involved in those negotiations, I wish that had been actually reduced to right now. Would prefer that, of course, Your Honor. But I'm not aware also of any case law that indicates that equitable tolling and estoppel issues would be negated by the lack of a written agreement either. I'm not aware of that. And clearly, there's plentiful evidence in the joint appendix that negotiations were ongoing and that the parties were doing so in an attempt to avoid having to continue with additional litigation. That was the entire point of that. So coming back to where I started, which was the purpose of a statute of limitations in the first place, the whole idea is so that a defendant isn't surprised by being sued. I mean, there was no surprise here, and that's why these equitable doctrines come into play, because they knew this was, hey, lawsuit had been filed, hey, there was a procedural thing here because there are 3 things down the chain. There was somebody that was a citizen of West Virginia. we're going to see if we can work this out first. If not, then we'll proceed on with some additional litigation. And so that, there's a strong public policy in West Virginia in favor of resolving disputes on the merits. Here, this case being dismissed because on statute of limitations grounds certainly does not dismiss it on the merits. They certainly weren't prejudiced, as they were involved the entire time. They had counsel involved the entire time. The suit had already been filed. It was just going to be going to a different court, and there was some attempts to try to settle it because there's also a public policy in favor of resolving disputes without litigation and clogging up our court time if we can do that. So we made an attempt to do that. And then lastly, I'd like to mention the continuous tort doctrine. There are issues of fact, at a minimum, that the court below failed to take into consideration, both in terms of the facts as described in the affidavit and the joint appendix from my client, Mr. Wilhelm, but perhaps more importantly, the affidavit of Dr. Bechtel, the expert who, in his affidavit, and I would encourage you to look at this, is a joint appendix 247 through 249. So there's two things I'd like you to look at here today in the joint appendix. One's the complaint, and the other is the affidavit of Dr. Bechtel at 247 through 249, because that affidavit makes clear that there was additional mine subsidence that occurred later than the time period which the appellees would like this court and wanted the court below to consider, but unfortunately, the court below did not take that into consideration. And in that affidavit, Dr. Bechtel specifically indicates that there was additional subsidence later than the time period that the defendants would want the court to rely upon. I think that's important because even if under that circumstance, there would be one, a continuing tort, and two, the statute of limitations would, if there was one, and if it was 2 years, would not start to run until much later. So for those reasons, and all the.
Let me ask you about that.
Yes.
And I understand your argument that there is no statute of limitations, and
Sure.
I'm not asking you to waive that, but if we assume there is some statute of limitations, what is the triggering of the beginning of that? Is it the activity of the mining company, or is it the moment that damage appears? And is your argument that each time new damage appears, if there is a statute, that the tolling is restarted when new damage occurs?
Yeah, so this is different. Thank you, Your Honor, for that question, because I would like to address that. The answer to that is twofold. One is, this is precisely why I think the legislature specifically intended not to create a statute of limitations, because of your question, which is that this damage continues and wouldn't be fair to the homeowner because it's under the ground. You can't go down and see, is this stuff still going to come down, and is that going to cause more sinking, et cetera. That's precisely why there's no statute of limitations. So anytime there's damage that's caused by the mining, they have to repair it regardless of when it happens, if it can be determined that's what it's from. But second, to answer your question, my answer to that would be is that when the last damage occurs would be my answer. But certainly, even under the circumstance where it's the last subsidence occurs, there's evidence in the record here in the form of the affidavit from Dr. Bechtel that last subsidence occurred where the ground shifted or moved or whatever the case may be later than what they're wanting to describe. So I think that the answer, though, I would think, or my answer would be when the last damage occurs is when the statute of limitations would, or the earliest the statute of limitations could begin to start running.
If you want to preserve a little bit of time, let's wrap it up if you got it.
Yes, that's all I had to say right now. I'll save the rest of my time for later, Your Honor. Thank you.
Good morning, Chief Judge Lawrenson, and Judge Quarrier, and Judge White. Thank you for hearing me on this matter. I'm Bran Altmeyer from Wheeling and represent the Tunnel Ridge Mine. In fact, I've been representing mines in subsidence matters for about 35 years. I'm older than I look. With me today is Jacob Altmeyer, who's related, is my partner. I'd like to begin with a personal comment that I think bears emphasis. I'm very uncomfortable being in a case where I'm attempting to enforce the statute of limitations. I've avoided that over my 35 years, and particularly in mine subsidence cases, I don't know how many I've defended, 70, 80, and I've frequently entered into tolling agreements with plaintiffs' counsel, and many, many times seen cases filed to preserve the statute and then stayed while negotiations continue. This is an unusual case in that no request for that was ever made, and the extraordinary amount of time that passed from when the plaintiffs themselves in their complaint admit awareness of damages, as Judge Cuomo found, no later than May of 18, they were aware of damages, and this case was filed 3.5 years later. Mr. Bordas went on at great length about the federal filing and so forth. The federal filing was dismissed on the grounds of lack of diversity jurisdiction. However, this complaint wasn't filed till 18 months later. And it's black letter law in West Virginia, obviously, I know the court's well aware, that if you voluntarily dismiss an action, the 1-year tolling does not apply. Whereas if it's adversely dismissed in West Virginia, there is a tolling of at least a tort statute for a period of 12 months to permit a refiling. But we were beyond that as well. Judge White, out of respect for you, I want to address the 22-116. We did research that, and our position as the co-operator is, I guess, twofold. If it does apply, the complaint still misses the statute. Again, based on Judge Cuomo's uncontested finding of fact that no later than May of 18, they were aware of the damages. It was 3 years and 6 months later that the case was filed. We believe, though, from an industry perspective, that 22-116 3-year statute was actually intended to rein in state enforcement of environmental regulations. 22-116 appears in the initial article of Chapter 22 and governs all of the environmental regulations. Of course, Chapter 22 having originally been enacted by our legislature in 1994, which was 12 years after the state adopted the Surface Mining Act in '82. That was an effort by the legislature to consolidate environmental regulation in a single act. And in any event, it is included in that act. We emphasize the fact that the language of that section talks about enforcement proceedings, whether they be administrative, criminal, or civil. They're proceedings to enforce compliance with the act. So in the case of the Surface Mining Act, which of course is one of only about a dozen acts included in that chapter, enforcement would be an action brought by the state. Now, I do want to emphasize, and I'm sure the court's noted it from the brief, that in order to file a private citizen's lawsuit under the Surface Mining Act, you must proceed under 22-325. 22-325 has 2 subsections that are in play, and the citizen can proceed under either one. 22-325A provides for an enforcement action. 22-325A is then qualified by 22-325B, and it sets forth a procedure for a private citizen that believes they have been damaged in their property as a result of a violation of the surface mining regulations, as was alleged here. That citizen can file under A, but there's a series of procedural steps they have to take, including giving a 60-day notice to both the coal operator and to the DEP. There's no allegation that any notice was given in this case. It's not asserted in the complaint. 22-325F, again, this was A. 22-325F is completely independent of those procedural requirements and simply recognizes a cause of action for damages, not for enforcement of the Surface Mining Act, but for damages brought by anybody like the plaintiffs herein who believe they've been damaged as a result of a violation of a rule. I want to touch on a very important point that I'm sure has occurred to the court. When does the statute of limitations begin to run in this case? Of course, we all have Judge Cuomo's well-reasoned decision on that you need an empirically demonstrable event, like a rear ender, if you're driving your car, from which you measure the statute. The only workable event here is the knowledge of the property owner that their property's been damaged. The plaintiffs, again, in both their federal and state complaint, assert that they had that notice in May of 18. Judge Cuomo found that as a finding of fact and even characterized it in a footnote as an uncontested finding of fact. It's interesting, though, the plaintiff alleges that one of the wrongs committed by Tunnel Ridge was failing to adopt technologically and economically feasible methods to prevent surface subsidence. Necessarily, that failure had to occur when the mining occurred. And we have submitted, and it's all part of the record, extensive evidence as to when the mining occurred. In this case, the plaintiff's home was never directly undermined by Tunnel Ridge, but there was mining laterally near it. Now, there would be an issue of fact if the case went back down on what we've denied liability, whether or not we caused that damage because of the proximity of the longwall panel. But nevertheless,
How do you respond to their argument that the statute should be sort of start anew every time there's new damage, and the affidavit from Bechtel that there's continuing damage after May of 18? How do you respond to the argument that new or additional damage after May of 18 should have restarted the clock, so to speak?
Yeah, the statement regarding the representation regarding the statement by Bechtel is incorrect. Bechtel never says that. Bechtel comments that additional subsidence damages occurred, and that always happens. I mean, when I'm sure the court is somewhat familiar, but in the longwall mining process,
I'm not sure I understand the distinction you're making. I mean, what's the if additional damages occurred? I think they're arguing when additional damages occur, that restarts it. And you're saying, I mean, he does say additional damage occurred. I'm not understanding your distinction that you're making there.
the distinction is between an action, as the West Virginia courts have repeatedly required, in order to support a cause of action for damage to property. There has to be some action taken. The only action ever taken by the mine operator in this case, and according to Judge Cuomo, this is uncontested, was underground mining.
Your argument is the important thing is the action of the mining company, not when the damage appears.
Yeah, and
Subsequent to the original notice.
Yeah, as held in the cases that we cited in our brief.
But I mean, you do agree that Bechtel says additional damage occurred after May of 18?
Yes, additional movement of the ground can occur. It's much like settlement in an old house, which I have in Wheeling. As time passes, the land tends to settle.
Now I agree with you that under traditional tort analysis, the act is what's important once notice is established, but if there's some act of the defendant. Is that changed at all, any, by the nature of this statute, where fault isn't necessarily required? Is if you mine and cause subsidence, there's this presumption that you caused it. If you're within the zone, you can rebut that, all that. But does that change the normal tort rule at all?
Absolutely not, Your Honor. The event, again, which triggers liability, as Judge Cuomo found below, is the occurrence of damage to a surface structure.
Or the discovery.
That is when notice, I apologize. That's when discovery occurs. But there is no tortious conduct here, and I agree with the court in noticing under 55-212, they never mention the word tort. That's any claim arising out of damage to property, which clearly this is a claim arising out of damage to property. And
But I think the distinction is, though, that it's, when you're talking about the continuing, the continuing action, is it not? It says, yes, it happens when the action occurs, but in this type of action, which is not tort, it's really a statutory.
that's correct.
Statutory one, is the continuing act. Does the Longwell have to continue to operate in order for continuing to apply, or does the damage have to continue to happen in order for the
To
continuing
create
apply?
a new statute of limitations, the long wall would have to again go under the house. That's correct. It only occurred once, during 1 week in 2017. There's no dispute on the record. His expert does not dispute that.
Okay.
Once that long wall machine passes, of course, the mine shaft collapses. Therefore, in terms of future mining activity, we have 2 affidavits, one from the mine manager and one from the environmental guy with the mine, both of which said no mining activity occurred anywhere in proximity, with miles away, subsequent to November of 17. We also have the timing maps, which all coal operators, underground operators, are required to file with the Department of Mining. Those timing maps show that we were gone by that time, but most importantly, as mentioned by our expert, Dr. Heasley, but you don't need expert testimony on this, it would be impossible to re-enter a collapsed mine shaft. It's sealed under the law. There's nothing there to go in. After a longwall mine passes, all strata above it drop into what was a 7-foot-high layer of coal, which is now gone. There's simply, it's an impossibility to have conducted continuing mining activity subsequently. I also want to refer, of course, the court, as you're well aware, the Roberts case in West Virginia cited in our brief. It was a defective water line. In that case, summary judgment was affirmed by the Supreme Court because there was no act by the defendant that occurred subsequent to the installation of the line. And the Graham Court distinguishes itself from Roberts by saying in that case, the installer of the drainage system serving a house, I believe, the installer of the drainage system had a continuing duty to maintain the drainage system. And therefore, the continuation of damages was additional overt acts. And lastly, the federal case that the plaintiff cites, McAvoy, I believe you pronounce it, which is Judge Bailey up in Northern District, he follows Roberts. And in Judge Bailey, in the McAvoy case, the same rationale. It has to be, in that case, it was an oil and gas operator that left well shafts open, and gas continued to emanate from this was property owned by the oil and gas company that was continuing to cause damage. But as my worthy partner mentioned one time, it hopefully helps to drive this point home, if you're trying to construe this as a repair issue, all a coal operator could do would be put the coal back. But obviously, that's not a possibility. So, again, on the statute of limitations, that's our position.
What's your response to their argument that this statute is to be interpreted consistent with the federal statute, and the feds one time back in 2000 and something looked at a Pennsylvania law and didn't like their statute of limitations?
Yeah, in this case, not my opponent so much as the Department of the Interior is wrong. There were 2 final rules published by the Department of the Interior, and we prepared a memo on that, but just didn't have time to file it prior to today's hearing. But there were 2 final rules published by the Department of the Interior. The one they rely on was 69 FR. That rule was published in 2001, was it? 2004. In that final rule, where there is dicta, what I mean by that is they were responding. It was a Q&A portion of the publication of the Federal Register. In dicta, they talked about that. What they were alluding to was the age-old, from the 19th century, position of the United States Supreme Court that a government agency is not bound by a statute of limitations unless it imposes that limitation upon itself. And that, in that case in Pennsylvania, Pennsylvania was going to adopt, I think it was a 2-year statute for the state of Pennsylvania to go in and require somebody to replace water. But that 69 FR incorporates by reference 66 FR, which was published by the Department of the Interior 4 years earlier. And in that section, noteworthy, they say, that the Ninth Circuit, basically, The proposition held by the Court of Appeals and cited by the state of Pennsylvania states that when a federal statute contains no limitation provision, an applicable state statute should be applied, unless there is an analogous federal statute or state law would frustrate a federal purpose. The Ninth Circuit case, this is the one they rely on, is the general rule applicable to litigation, but not applicable to private parties. And again, the big distinction here is this is under 2235 subsection F, which is a private party cause of action. And even under the federal standards, and there are several Supreme Court cases on that as well, even under the Supreme Court cases, it's a line of authority stretching back to the 19th century. But it is most recently in the Supreme Court case of Del Costello, U.S. Supreme Court, which is cited in our brief. In Del Costello, they again say that the general rule under federal law involving private actions, which is what we have here, meaning a private citizen, a lack of a statute of limitations in a federal statute means the court should look to state law for the applicable statute. And that's the United States Supreme Court following precedent in 1966 and then further precedent going back to the 19th century. Unless Del Costello, what that case stood for was it announced the proposition that with regard to state action, whether it be the state of Pennsylvania or the federal government, with regard to state action, state law statute of limitations do not apply. The government is not restricted. But when it comes to private claims, as was presented in the Ninth Circuit case and addressed in the earlier Federal Register publication, in the case of private actions, as has been the law of the United States since like 1860, in the event an action is brought under a federal statute and there's no statute of limitations contained in that statute, the court looks to applicable state law. There's probably 40 cases to that effect, countless. Does that answer your question, Judge?
I think we understand your position. Do you have anything else you'd like to share with us?
I'm going to take just a quick.
The minute you have left.
1 minute, thank you. My opponent started with sort of an argument in equity that when undermined mining occurs, it's delayed and you're not aware of the damages and so forth, so it's difficult to apply a statute. Bear in mind here that the court found they were aware in May of 18. Over 3 years before the case was filed. By their own admission, they were aware then. The idea that it's not a tort claim and shouldn't be subject to a 2-year statute, I want to note that the plaintiffs kind of surprised us, filed their action in federal court in April of 2020, carefully asserting that the plaintiffs became aware of the damages in May of 18. I mean, I don't fault them for doing it. They were beating the statute that they knew applied. On the estoppel arguments, I would refer to Judge Greer's excellent opinion in the Bradley case. It was an Intermediate Court of Appeals case just decided in November of last year, talking about the merits of applying a statute of limitation, the judicial policy behind it, and also that exceptions to the statute, including equitable estoppel, are to be strictly construed.
I think we understand your case is submitted.
Thank you, Your Honor.
You have, I think, 3 minutes left.
Thank you, Your Honor. I want to circle back to something that was asked previously of me and also was addressed by opposing counsel there. The question was about when does the statute either begin to run or when's the last date on which it could begin to run. And I think that maybe we're missing the forest for the trees slightly here. And the reason I say that is I want to encourage your honors again to look at the complaint, which is found in the Joint Appendix 14 through 19 when you're looking at this. We didn't sue for property damage. That's not what this lawsuit is about. This lawsuit is to seek enforcement of a statute that has been violated, because the law says that you can do that. And the applicable date is not when the Mining Act occurred. It's not, or the mining, their mining activities occurred. It's not when the damage occurred. It is when their failure to repair occurred. because that is what we are suing for, is to enforce the statute that says they have to repair, and their failure to repair is ongoing even to today. They have still failed to repair. They've never repaired. So the statute of limitations, if there is one at all, still hasn't begun to run because they still have not repaired. And if you look at our complaint, that is what our complaint is all about. It is to seek the enforcement of the statute that says they have to repair. And our legislature enacted that for good reason. And that's what we're seeking to enforce, is their obligations under that act to repair the property if it's damaged, and they continue to not meet those responsibilities. So I want to make that clear. Second, they indicate that we didn't ask for a tolling agreement, and he's had many instances throughout his career when people have asked for tolling agreements or he's entered into one. There's no reason to ask for a tolling agreement if there's no statute of limitations to toll. And this statute provides there is no statute of limitations within this type of action. This is the enforcement of a remedial statute. Clearly, remedial statutes are to be enforced liberally. And again, we're not suing for the damage itself. We're suing for the enforcement of this statute. Lastly, I would like to say that even if the court would for some reason disagree with me that the failure to repair is the triggering act, and that continues to today, if not, then clearly when the subsidence occurs has to be the defining act. And Dr. Bechtel does address that in his affidavit. He addresses it in paragraph 12, where he says that the new damages occur between November 2019 and March of 2020. I mean, he says that right in his affidavit. And that's the reason that the legislature separately created this statute, is that with damages of this nature, theoretically, their argument would be is, look, if sometime, let's say we file an action and they go and they start their repairs, and then an entire wall collapses because the ground still hasn't completely finished moving and it's doing all these things. Their argument would be is my clients would be out of luck for that wall collapsing because it had been beyond 2 years when the wall collapsed. That's an absurd proposition. That is additional damage that has occurred as a result of the mining activities that they conducted. And that's the nature of mining activities and why it's so different. That's why this legislature had to enact this statute, is that it continues to move under the ground. It doesn't happen all at once. Just because they run the longwall through there on one particular date, that doesn't mean all the damage is going to happen then. And that's why this is so different than, say, like my neighbor driving his vehicle through my yard and property damage occurs. Like that happens, and then like you can see what that damage is, you know what that's occurring, and you can file a lawsuit for that property damage. This is so different than that, and that's why the legislature created this separate scheme for this. Yes, Judge White.
So under your theory that the damage is what triggers the statute of limitations, if the statute of limitations is applied and the first damage is outside of the statute of limitations, but the second damage is within the statute of limitations, does that mean you do not, the person asking for enforcement does not, is not able to recover for the damage that occurs in the first set of damage?
I understand your question. So presuming that there is a statute of limitations, which I'll presume for your question, the answer to that would be no, because it would be absurd, because what would necessitate then is citizens to go out and file a whole bunch of different actions. Like when this thing occurs, now I'm going to file it. When this occurs, now I'm going to file it. And that's why the legislature recognized that we're not going to do this. What we're going to do is say any damage that's caused, they got to repair it. If it was caused by the mining, then, and it's determined through evidence that it was caused by the mining activities, then you can get it. So that's the reason for that. In conclusion, I do want to mention that we believe that the circuit court below should be reversed. This court's not required to give any deference to the court's findings below. This is a de novo standard here with respect to this. We would ask your honors to take a look at this and reverse the court's ruling and allow this case to proceed on the merits and on the evidence as cases should be done in the state of West Virginia, not on, hey, maybe I got you here because maybe this statute of limitation applies and maybe this was beyond this for these particular damages, even though we knew about it, we were all negotiating, even though you'd filed a lawsuit before against us, even though Everybody knew that this was coming, even though we were trying to work it out before having to file more litigation that clogs up the courts, and instead allow this to be decided on the merits of the case. Thank you.
Case will be submitted.
First on the Rule 19 docket, Hall Property Group LLC et al. V. Quarrier Street LLC et al., number 24 ICA 67, an appeal from the Circuit Court of Kanawha County. Judge Brian White is voluntarily recused, and Judge Laura Faircloth is sitting by temporary assignment.
Welcome, Judge Faircloth. Thanks
you.
for coming down.
Thank you. It was a long trip.
It is a long trip. What is the new circuit for Berkeley Morgan?
It is the 27th.
The newly designated 27th. We're honored by your presence, Judge. Thanks for
Thank you.
joining us.
I'm honored to be here.
We're ready for the petitioner's counsel to present. Wanted to give you a little warning on reserving time. Feel free to get up there, but this is Rule 19, but we'll be a little liberal. We've been liberal with time, and obviously we're running a little behind time. Understanding that we didn't make arrangements specifically with respect to addressing the cross assignment of error. So I would ask that you, in your reserving time, understand that you'll be also responding to the cross assignment. So would you like to reserve some time?
Yes, thank you, Your Honor. I would like to reserve 4 minutes of
4
rebuttal.
minutes. You may proceed, please.
Good morning, Your Honors. May it please the Court. My name is Robert Stonestreet, and I represent petitioners Charles W.V. Mall and Hall Property Group. The main question presented in this appeal is whether the trial court erred by granting partial summary judgment after deeming the language of a contract to be unambiguous based on the trial court's consideration of disputed extrinsic evidence after previously concluding that a question of fact existed as to the intent of the parties based on the exact same contractual language in the absence of disputed extrinsic evidence. The trial court had it right the first time. There's a question of fact regarding the intent of the parties. The language of the contract is ambiguous, therefore a jury question existed and summary judgment should not have been awarded. This dispute primarily arises from 2 documents. One is referred to as a demolition agreement between respondent Quarrier Street LLC and respondents collectively identified as the trust defendants. It was executed in August of 2020 and purports to reflect understandings between those parties concerning the demolition of a former Sears building that was once attached to the Charleston Town Center Mall. The second document is a purchase and sale agreement between Charles W.V. Mall and the trust defendants for the sale of the Charleston Town Center Mall. Executed in April of 2021, it consists of 73 pages, including all exhibits and ancillary agreements. The crux of this dispute is whether the parties intended, as part of the sale of the mall, for the trust defendants to convey and Charles W.V. Mall to accept an assignment of the demolition agreement for the Sears building. In December of 2023, the circuit court denied a motion for summary judgment, finding that there was a genuine issue of material fact as to whether there was an intent to convey and an intent to accept this demolition agreement. The trial court also found in the same order that there was a question of fact as to whether the demolition agreement itself is supported by consideration. If there's no consideration for the agreement, it's not an enforceable contract and thus could not be assigned. Just over a month.
Obviously, nobody appealed, or you can't really appeal that, be interlocutory, but nobody filed a petition for writ of prohibition to challenge those findings, right? So that the circuit court retained that case, and I believe a new judge, Judge Akers, came in after certain, well, I don't know, that may not be true, but basically there's additional discovery, and Judge Akers deals explicitly with what facts arose post the earlier decision to arise at her conclusion that summary judgment was warranted. Is that correct?
Well, Judge Akers presided over the case the entire time.
Okay.
The December order was resolving a motion that was filed back in January.
Okay.
The next order, which I'm about to talk about, that addressed a more recently filed motion. And in that more recently filed motion by the trust defendants, that motion addressed various discovery evidence that was developed in discovery. So you have the December order finding question of fact, ambiguity. A month later, the same judge finds that the same language is now no longer ambiguous, specifically based on testimony by one of the petitioner's corporate designees and other testimony that was in discovery. Basically construed that evidence against us as the non-movement and found that now there's no longer a question of fact because of this extrinsic evidence that's been considered. So that's the main point of our appeal. If the language was ambiguous as found in December, it's up to the jury to consider this extrinsic evidence and resolve that ambiguity and determine what the intent of the parties was. Instead, the judge did
The
that.
question now is whether it's ambiguous or not. She found in the last order that it wasn't ambiguous, and she was going to apply its terms, correct?
Correct.
So if, I mean, isn't that really the question? Does the assignment and the agreement, does it include this demolition agreement or doesn't it? Isn't that the question?
That is the question, Judge Greer, yes.
And if these clearly are unambiguous, and they're included, then she got it right.
If that's the case. Our contention is obviously she did not. The associated words canon of construction really can resolve this. If you look at the types of agreements that are identified in the purchase and sale agreement and the assignment executed pursuant to that agreement, these are service and maintenance contracts for things that happen at the mall, providing telephone service, water service, landscaping services. That's the kind of contracts that are assigned. The demolition agreement doesn't involve services to the mall. It governs demolition of a piece of property not owned by the mall. It was connected to the mall, but if you look at...
And affects operations at the mall, right, according to...
It can, well...
I mean, it may not, I'm sorry, I interrupted your question. Go for it. I was going to say, I mean, it may not have been on the property, but it was the wall. I mean, it is the wall. Whoever's property it's on, it is the wall.
It would have been an exterior wall for the mall, yes, but it was on the Quarrier's property, correct. So we don't contest that taking that wall down would affect the mall, but looking at the language of the assignment and the PSA talks about service and maintenance contracts relating to repair, service, operation of the mall. Our contention is when you look at the entire contract, the PSA particularly, that reflects the intent of the parties. This assignment was executed pursuant to that. And when looking at in total, it shows you the types of contracts that would be assigned, and the demolition agreement is clearly not one of those types of contracts because it doesn't have anything to do with providing service or maintenance activities at the mall. It governs the former Sears property. And I see my 6 minutes have expired. Unless there's any further questions, I'll defer to my rebuttal.
Thank you.
Good morning, Your Honors. My name is Isaac Foreman on behalf of Respondent Quarrier Street LLC, and it is my intention to address the cross assignments of error in the 5 minutes that I have with Mr. Spitz to address the remaining issues in the balance of the 5 minutes. We have raised 2 cross assignments of error in this appeal. The first is that the Circuit Court erred in denying Quarrier Street's motion for partial summary judgment on the issue of the assignment of the demolition agreement. The second is that because the trust defendants remain bound to the demolition agreement, it was error for the Circuit Court to award summary judgment in favor of the trust defendants on count 1. Turning to the first assignment of error, the assignment agreement is quite clear. Mr. Stonestreet talks about the crucial documents being the demolition agreement and the PSA, the purchase and sale agreement. This court doesn't need to look at the purchase and sale agreement. The only document that matters is the assignment and assumption of leases and contracts. It is a standalone contract. It does not reference the purchase and sale agreement. It does not incorporate the purchase and sale agreement, and it contains its own definitions of leases and contracts, which very clearly encompass the demolition agreement. Our second cross assignment of error is that the Circuit Court erred in awarding summary judgment to the trust defendants because notwithstanding an assignment, and we believe the Circuit Court was correct in concluding that that agreement was assigned, but when a party assigns a contract, the original contracting party is not released.
But that's not raised that's not raised in that count that you're complaining of. That theory of liability you're giving to us now, but that's not raised in your complaint.
Our complaint alleges that the trust defendants breached their contract. Yes, and I know in the trust defendants' reply brief, they seem to suggest that this issue was never raised. It was. We have consistently argued that both parties can be held liable by the jury for breaching a contract.
When in the pleadings was that raised below? Because I mean,
Sure. In the joint appendix at 1683, there's a block quote that the trust defendants excerpt that they put in their brief. They omit the immediately preceding sentence where we say both defendants can be held liable for breach of contract. We have never conceded that the assignment will release the trust defendants. We've never argued that it would release the trust
how can
defendants.
you though complain about a granting of summary judgment in a count where the theory of liability that you're espousing now isn't addressed in that count? I mean, that's what we're here about is count one, the summary judgment. And if you don't lay out that theory of liability in that count, how is it incorrect for the court to grant summary judgment?
Count one of our, sorry, it's not, it is count one of our complaint. The breach of contract against the trust defendants says we had an agreement with them and they breached it. It's not limited to the issue of the assignment.
But those are the only allegations, though. The only yes, that's what it says, but the allegations in count one are you breached it because you didn't bind them. That's what it says. It doesn't say, or in the alternative, you are still on the hook. That's not in there. I mean, you're making that argument now, and that may be a cogent claim, but I don't read that to be in count one.
And count one also alleges the breach of the duty of good faith and fair dealing, Your Honor. It is quite clear in this case that if the trust defendants had merely emailed a copy, we spent 2 years negotiating with the trust defendants the demolition agreement, and if they had merely emailed a copy of it to prospective purchasers or put it in the data room that was set up for due diligence, that we would not be here today. So we spent 2 years negotiating a contract with the trust defendants. They then market them all, which we're unaware of. They didn't disclose the agreement to any prospective purchasers, despite an obligation that they were required to bind successors and assigns. That is obviously a breach of the contract. It is quite obviously a breach.
The court found that they did that. The court found that they did that. So, I mean, you can't complain about that because the court found that in your favor.
I certainly can, because but for their failure, we would never have had this litigation. Yes, a court now, 2.5 years after the fact, has decided that it was assigned, but in the meantime, we've been stuck in litigation because of their failure.
Is that contained in, are you alleging that in count one? Because we have to be bound by what you actually put in count one. Do you?
At the time that we filed the complaint, Your Honor, we didn't have a copy of the assignment agreement. We got it in discovery subsequently, and as soon as we did, we filed that partial summary judgment motion in January.
Let's talk about your other cross-claim, as I understand it, is that you're complaining that you weren't granted summary judgment against another defendant.
That's right.
How does that relate to count one? Because all that's been decided is count one.
So I noticed that I'm at 4 minutes and 30 seconds. I want to talk about this issue because it's raised in the reply brief, the question of whether this court has jurisdiction over those two cross assignments.
Correct.
It does. The Supreme
Why?
Court of Appeals of West Virginia in Cabell County Commission versus Witt, this is 242 West Virginia 382. It's a 2019 decision, acknowledges that you have appellate jurisdiction over issues that are inextricably intertwined with a subject that is the proper subject of an appeal. When an issue is inextricably intertwined, you absolutely have appellate jurisdiction. And the Supreme Court in the Witt decision cited expressly to the United States Court of Appeals for the Fourth Circuit, which has a very well-developed.
We are a different creation, though. The Supreme Court has ability to hear all kinds of things, interlocutory and otherwise, that we don't. I mean, just because they're talking about their ability, I wouldn't necessarily assume that we have that same ability, because they can do a lot of things in interlocutory orders and have jurisdiction and extraordinary remedies and such that we don't. If we don't clearly have it, we don't have it. So I'm not sure that their statements about what they can do 20 years ago necessarily applies to us.
Well, the Witt decision was from 2019. It was not talking about the ICA, but this is not an interlocutory appeal. This is a certified final order.
Count one is, but that's not what you're asking about in your other counterclaim.
Well, I should say it's
Cross-claim, excuse me.
That's correct. And this court has jurisdiction because it is inextricably intertwined with the issue that is on appeal. What the Fourth Circuit cases that the Supreme Court cited say that you will have jurisdiction over an inexplicably intertwined issue when the same specific question will underlie both the appealable order and the non-appealable order, such that resolution of one will necessarily resolve the appeals from both at once. That is from Ely versus Pinkerton. It's 514 Federal Appendix 299. The final issue, Your Honor, is that with respect to a Rule 54B certification, the Supreme Court of Appeals has said that you should keep in mind the purpose and the practical implications of the rule. This is Province versus Province, 196 West Virginia 473. The purpose and the practical implications of this appeal are to give guidance to the circuit court, which in its certification order acknowledged that this issue, the assignment, is central to the remaining claims to be tried. We have an opportunity during this appeal to resolve issues that are inextricably intertwined and necessary in order to ensure meaningful review. And I have taken already more of Mr. Spitz's time than I intended, so.
We'll allow him to go a little further since he's disagreeing with you on some things, but wrap it up if you would.
Certainly. This court has an opportunity. Look, there's no question this case is going back to the circuit court. It is going to be tried. When we have issues here that are inextricably intertwined and necessary for meaningful review, there is no reason not to review them. And the Supreme Court of Appeals has been clear that you have the authority to do that.
Well, they haven't been clear whether the ICA has authority to do that. They may say they do. They haven't said we can.
Certainly not.
And oftentimes they tell us we can't.
The province decision was in the context of a 54B certification. This court absolutely has jurisdiction over 54B final orders. Judge Greer, you wrote that opinion not too long ago, explaining why this court has that jurisdiction. The point is that both of our cross assignments of error are inextricably intertwined and essential to have meaningful appellate review in these circumstances so that we're not back after a final judgment arguing and briefing the exact same issues when the circuit court in its certification order said we need clarity on these. That is the purpose and the practical efficiencies of the rule.
Thank you so much, Mr. Spitz. I'm going to continue to give you 4 or 5 minutes. 5 minutes, please.
Thank you, Your Honors. I'd like to start, if I may, addressing an issue that you seemed interested in that no one filed a writ of prohibition over the first order prior to the second order being entered. Your Honor, under Rule 54B, the trial court retains jurisdiction and can alter and amend its prior orders at any time if it sees fit. So the court has that authority under Rule 54B to redecide the issues. And that's within the court's authority. That's what happened here. It's perfectly appropriate. Second, Mr. Stonestreet said that in the first order, the court found that there is a disputed issue of fact as to whether or not consideration was exchanged for the demolition agreement. That is incorrect. Paragraph 18 of the first order, Joint Appendix 1903, notes that defendants Hull and CWV contest that there was mutual assent to convey the demolition agreement, and that there was consideration for the demolition agreement. The court then went on in paragraph 20 to discuss what it thought the contested issues of fact were. That is not the court finding that there was a contested issue of fact with respect to consideration for the demolition agreement. Moreover, Your Honors, at the summary judgment stage, the party cannot simply rest on arguments, right? Under Rule 56, you have to provide evidence, affidavits, responses to interrogatories, testimony from witnesses. The only evidence that was admitted into the record before the circuit court was the demolition agreement itself. I can't give you the joint appendix site, but you have it. The demolition agreement itself states that valuable consideration was exchanged between the parties. It then goes on to list, and it's joint appendix 1269 is the page that I'm referring to. It then goes on to list the rights and responsibilities undertaken by Quarrier and the rights and responsibilities undertaken in exchange by the mall. So consideration was exchanged between the parties and supports the demolition agreement. With respect to the assignment and assumption, the assignment and assumption specifically states that it includes any and all contracts related to the upkeep, repair, maintenance, or operation of the mall. That language is not ambiguous. It is not susceptible to differing interpretations. The fact that there is an exhibit that lists out contracts that will specifically be included is addressed. It says these contracts include but are not limited to those listed in Exhibit B. Right? That language, not limited to, that is unambiguous. Right? It was appropriately construed by the trial court to find that any contract that relates to the repair, upkeep, and maintenance of the mall, was assigned to CWV.
That included oral agreements, right?
That would include oral agreements, Your Honor.
It specifically does in the language of the contract, which,
Yes. And
which would be hard to show evidence of.
yes, and Your Honor, with respect to what information had to be conveyed to Hull on the front end, right? The purchase and sale agreement gives a list of review items, all right? And it specifically says that Hull has to be given service contracts. Hang on, if you give me one moment, I can read the specific language. Service contracts and maintenance contracts and equipment contracts at Joint Appendix 1327 through 1328 were what were required to be provided in advance to Hull. Hull admitted in its corporate representative deposition that the demolition agreement is not a service contract, a maintenance contract, or an equipment contract. In that same deposition, Hull's corporate representative admitted that the demolition agreement relates to the operation of the mall because tearing off a side wall of the entire mall impacts the operation of the mall. All right? And so there is not a genuine dispute of material fact as to whether or not the demolition agreement is an agreement or contract that relates to the upkeep, repair, and maintenance or operation of the mall. And so we apply that language, and as such, the demolition agreement is assigned to Hull. And if I may very quickly respond to the cross claims, I'll just super fast. You're correct, it wasn't raised below. The cause of action is you failed to assign the demolition agreement and therefore breached the demolition agreement contract, which required you to assign it to your successors in interest. By the court finding that the demolition agreement was in fact assigned, it found that there was no basis to find a breach of contract. The court did not make any findings as to whether or not the trust defendant's obligations under the contract terminated as a result of the assignment. The reason there are no findings, one way or the other, by the trial court on that issue is because it was never raised to the trial court.
What about the other count of the cross claim, or the cross assignment of error?
The other count goes against him.
Okay, I apologize, that's right. I get all y'all confused, I apologize.
I'm the one without the beard. Do you all have any, may I please answer any other questions?
I think we understand where you're coming from. Thank you.
Thank you all very much.
And you have your originally reserved 4 minutes.
But I'm gonna start you off with my question. What's your response to his cross claim that court should have granted summary judgment for him on his claim against you?
Well, my response is, when the court granted summary judgment for the trust defendants, it was the same issue, interpretation of the contract. And when Judge Akers did that, she went through and considered extrinsic evidence that was disputed. Our witness, Mr. Mueller, that Mr. Spitz referenced, did not admit that the demolition agreement falls within the scope of the assignment. He did not. He said if you tear the wall down, it will affect the mall. But within the meaning of what the parties intended as to contracts being assigned, it doesn't fall within that. He squarely said that. And we've cited that transcript in our briefs repeatedly. They did not, and neither did they. And that's because the way you read that transcript, you can read it and his testimony can be considered in different ways. There's a dispute there as to what the parties intended. When you look at that actual language, it shows that. So the reason that our main problem here is the judge considered extrinsic evidence that's in dispute and construed it against us instead of in our favor, and found that there's no longer a question of fact, which is a jury question. That was not for her to do. That's for the jury to resolve. Does that answer your question, Judge
My
Greer?
question was the jurisdictional issue of can this court hear his second cross assignment of error?
We don't take a position on that. The reason we're here is because we want a jury trial on the claim against us.
Fair enough.
Now, whether those two can continue to fight it out, we don't really take a position on that. With respect to the purchase and sale agreement, Mr. Foreman indicated you don't have to look at that, it's irrelevant. It's very, very relevant because the assignment was executed pursuant to that. That's the reason for it. So if you look at the assignment and you have a question, well, what did the parties mean by this? Look at the purchase and sale agreement, which is the reason for the assignment, and see what they agreed to there. That would inform the court or the jury as to what is meant there. The judge did not look at that. If your honors find that there is no ambiguity in that assignment, you can still find in our favor. There's two ways to do that. One is you can find under the PSA what the parties really meant is for these specific service and maintenance contracts to be assigned and not the demolition agreement. Second is you can apply the Bradford case, the associated words canon of construction, and look at the language, look at the context for everything, and consider, do you think the parties really intended to assign an undisclosed agreement that we contend lacks consideration for the demolition of an entire building connected to the mall when we had no idea it even existed? Do you think the parties really intended that? No, they didn't. They did not. And the jury can certainly find that from the circumstances and the evidence presented and the testimony that all the people, all the witnesses would give.
I may have all these parties confused, but the first cross assignment of error is he's saying the court should have granted summary judgment for him against your client, correct?
Originally. Yes, that's an interlocutory order.
And that is my question. I'm getting
sorry.
the first and second cross claims confused.
Okay.
But my question to you is your position on whether this court has jurisdiction to hear his cross assignment of error that the court should have awarded him summary judgment against your client.
I'm sorry, Judge Greer. I understand your question, and the answer is no, you do not have jurisdiction. It's an interlocutory order. If he wanted to challenge that, he should have moved under Rule 54B or sought a writ to the Supreme Court.
I apologize for asking my question, because like I say, I'm trying to keep everybody straight.
Not a problem.
I'm doing a poor job. I apologize.
They're not a problem. And Judge Lorison, you had asked some questions about the language of the assignment, or the language of the demolition agreement. If you look on our brief, our opening brief from page 6 to 9, we walk through each clause that Quarrier maintains would support a conclusion that the demolition agreement relates to the operation of the mall. We explain in detail why each of those clauses only govern activities on the Quarrier parcel, the old Sears building. It doesn't talk about the mall. There's no authorization to go into the mall. There's no authorization to do anything on the mall property. They're doing all this stuff over here. It does not relate to the mall's activities. All kinds of things can affect the mall, basketball tournaments, anything else that's going on in Charleston, closing of the JCPenney store. There's things that are going to affect the mall. That doesn't mean that the parties intended to assign an undisclosed agreement to tear down a part of a building that serves as one exterior wall of the mall. And unless your honors have any other questions, then I'll conclude. And I would just ask, our request for relief is to vacate the January 16th, 2024 order and remand the case for trial. Thank you.
We understand your case, and it will be submitted. Thank you.
All rise and be silent. This court is again in session. Please be seated.
Welcome, Mr. Clerk.
Thank you, Chief Judge.
Can you please call the next case?
The last case on the Rule 19 argument docket is Steak Escape 2 LLC doing business as Steak Escape and Josh Macleery v. Jason Hudson, case number 24 ICA 173, an appeal from the Circuit Court of Kanawha County.
Counsel, this case is set as a Rule 19, which usually means 9 minutes, but I guess in my timekeeping, it can mean, or usually it's 10 minutes aside, excuse me, but I've been a bad timekeeper. And we seem to be a hot bench today in the last couple of days, so I'll give you additional time if we start filibustering you. But would you like to officially reserve a little bit of time for rebuttal?
Yes, Your Honor. I'll reserve 2 minutes for rebuttal, please.
Yeah. And you may proceed. Thank you.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the court, my name is Andrew Mons from the law firm of Jackson Lewis, and I'm here to represent petitioners Steak Escape, of Kanawha City 2 LLC, which for ease of reference, I will just refer to as Steak Escape, and the other petitioner, Josh Macleery. Your Honors, petitioners are here today simply to get their day in court to get a ruling on the merits of this case. The trial court improperly granted default judgment and then committed clear error by denying petitioners' motion to set aside the default judgment. The evidence in the record makes it clear that the trial court abused its discretion by refusing to set aside the default judgment. The Supreme Court of West Virginia says that when it comes to default judgments, there's a presumption in favor of adjudication on the merits of the case. However, the trial court ignored this presumption and refused to set aside the default judgment despite clear evidence that petitioner, Steak Escape, was never served with the complaint, and that both petitioners met the criteria to set aside based on good cause and under the factors laid out by the Supreme Court in Parsons. Regarding service of Steak Escape, as pointed out in petitioner's brief, the default judgment should be set aside for the clear reason that Steak Escape was never served. It is undisputed that the summons and complaint for Steak Escape was never left by the deputy sheriff when the deputy sheriff came to the Steak Escape location to serve the complaints. Furthermore, there is no evidence that Josh Macleery refused service on behalf of Steak Escape, nor any evidence that he had the authority to do so at all. Simply put, the complaint and summons were never served on anybody. Respondent then attempted to serve Steak Escape through service by certified mail via the West Virginia Secretary of State. However, this mail was never delivered, and it was returned to respondent marked as not delivered as addressed. Under West Virginia law, service through certified mail is not effectuated if there is no proof of delivery. As the briefs describe, the address Steak Escape listed with the Secretary of State was a valid address of one of its partners here in Charleston. There was records provided to the trial court that address had receives mail and can receive mail. Steak Escape and petitioners do not know why that particular piece of mail was returned to respondents. But the bottom line, there's no evidence that the mail was refused by petitioners.
How many times was it attempted?
I believe the record, there's evidence of the record that it was 3 times it was attempted to be delivered, but what that consisted of, Your Honor, I'm not sure. That's just, I believe, what the Postal Service records indicated.
Just to be clear on the service issue, when the default judgment was dealt with below, in terms of the evidence that was submitted to support service of Steak Escape, it was only the Secretary of State information, correct? There was no evidence offered of service of Steak Escape through Macleery introduced below, was there?
Well, I guess by below, it's a little complicated, Your Honor. So when respondent moved for default, I believe the only evidence that was provided to support the default was the demonstration that the mail was not delivered.
That's what I was referring to.
But yes, but further, the trial court, after petitioners filed its emergency motion to set aside, trial court allowed for discovery, and through that discovery, there's been more information that was developed about the inner workings of the actual service, attempted service by the deputy sheriff. But as far as what was before the court when it ruled on default was the mailing records indicating that it was not delivered.
So you don't dispute that Macleery was served?
Yeah, Your Honor, no. Josh Macleery was handed a copy of the summons and the complaint and was served. And we have not argued.
And there's nothing about him not refusing or not taking service on anything?
Well, that's our argument, yes. I think what respondents argue in their brief is that Josh Macleery somehow refused service on behalf of Stake Escape, of the complaint that was attempted to be served on Stake Escape. And there's just no evidence for that. The evidence shows that the sheriff said, "Are you Josh Macleery?" He said, "Yes, here you go." And he said, "Michael Hill," which was another defendant, which the trial court did set aside the default against him. The sheriff handed the summons for Michael Hill to Josh Macleery, and then said, "What about Stake Escape?" And Josh Macleery said, "Well, they're in Ohio." And
did the trial court make a finding about what the respondent claims about Macleery, the service being on Macleery on behalf of Stake Escape? Did the trial court touch that at all?
To be honest with the Honor, no, not specifically. And the trial court from my perspective, kind of glossed over the whole service issue and focused a lot on the address that Stake Escape listed with the West Virginia Secretary of State and how they have an obligation to list a valid address, which I think the evidence shows that they did. But as far as the whole issue of them not being served at all, and the trial court really, in my opinion, just glossed over that and didn't focus on it at all.
Well, in the order dealing with your refusing your motion to set aside the default judgment, paragraph 19, the court says Stake Escape admitted that it received the complaints and summonses delivered to Josh Macleery. And I assume what you're saying there is they admitted that the Macleery and Hill summonses were received, but not the Stake Escape summons. Your theory is the Stake Escape summons was not left with Macleery, is that right?
Correct, Your Honor. Yeah.
I just wanted to make sure I understood
Your Honor, your reading of that is correct, and I think your summary of the evidence is correct. Okay. We don't dispute that Josh Macleery was handed the complaints and summons.
So you represent both Josh Macleery and Stake Escape of Kanawha City 2 LLC.
Correct, Your Honor.
I think actually, I mean, I understand why you shorthand it, but it's interesting. The shorthand confuses issues kind of like what you've done in terms of accepting service and dealing with this matter. Actually, precise party names are important, I think, because I was a transactional lawyer. Obviously the LLC law applies here, not corporate law. It's a West Virginia limited liability company according to the record. The West Virginia limited liability company law says that for a manager-managed LLC, the manager listed has the authority to bind an LLC. It's presumptive. That's the agency created. And in this case, you've got Stake Escape of Kanawha City 2 LLC, manager listed Mr. Macleery. And I know there was testimony that was inadvertent and whatnot, but that can't inure to the detriment of a plaintiff trying to initiate a lawsuit. How do you respond to the fact that he physically received complaints and summonses?
He physically received complaints and summonses addressed to himself as an individual defendant and another individual defendant. He did not receive a summons and complaint addressed to Stake Escape of Kanawha City 2 LLC. So I don't think he can bind the LLC, even if you accept that he's a manager of the LLC, which, as you noted, we contend he's a manager of a Steak Escape restaurant, not a manager of an LLC. But even if you accept that that is the case, he didn't accept any service on behalf of Steak Escape LLC, of Kanawha City 2 LLC, if we want to be precise. That was never given to anyone. So he couldn't accept that. The service that he accepted was on behalf of himself and Mr. Hill, which the trial court acknowledged he couldn't accept it from Mr. Hill. So Mr. Hill was never served.
So let me get this straight. Are you saying that the complaint that he was served didn't mention Steak Escape?
I mean, I think the complaint, it lists Steak Escape, yes, it lists, I'm not contending that, Your Honor.
Okay.
I'm saying the summons does not list Steak Escape, is not directed to Steak Escape that he received. I think the complaint itself does say that Steak Escape is a defendant, or excuse me, the LLC, if we're to be precise. But I think there still was not actual service of the complaint upon Steak Escape and the summons upon Steak Escape.
Would, if we were to find that there was not valid service with respect to Steak Escape, but there was with respect, and it's admitted with respect to Josh Macleery, and that your other rationale for us reversing the circuit court's order that sustaining the summary judgment order, and that would apply solely to Mr. Macleery, was he acting as an agent? I mean, is that going to be the same thing? Is there a respondeat superior nature of the liability that's going to flow to Steak Escape anyway, or at least you have a right to contribution from you? I mean, does that get you remedy?
Well, if I understand the question correctly, Your Honor, you're saying if you found that there was no service on Steak Escape, am I correct on that thus far?
These are all in arguendo.
I understand. I'm not saying you're finding that. I'm not previewing your decision. If you find that Steak Escape was not served, and therefore the default judgment against them is invalid, we'd still argue that the default judgment should be reversed against Mr. Macleery under the Parsons factors, because as we argue in our brief, the factors favor the petitioners. And in particular, the factor that, really the only factor addressed by the trial court, intransigence, there's simply no evidence that Mr. Macleery was intransigent in any way. He had notified his superiors of that he had been served with the complaint and the summons. He provided them, I believe, specifically he provided them the one addressed to Mr. Hill. And he was told that the company would take care of it. He helped provide interrogatory responses, and that's another point I wanted to make for both petitioners. Even if you find the Steak Escape was served, I don't think the intransigence is here, Your Honor, where
the fact finder says defendants have demonstrated complete intransigence. I mean, that's the finding of fact by Judge Bailey, right? I mean, the circuit judge in this case. I mean, do we afford no weight to that in our review of her granting of this?
Well, I think it's under abuse of discretion standard, but I think that finding, her determinations were at abuse of discretion based on the evidence of the record. I just, in a situation where a party provides responses to interrogatories that were provided with the complaint and summons, and is under the belief, as testified, that that was all they needed to, they believe that satisfied their obligations, and then there's a motion to set aside a few months after a response would have been due. The complaint was filed in August of 22. We filed our motion to set aside early March 23 with an answer. That's not a significant delay. It's still well within the statute of limitations based on when the respondent left his job. There's still, there would have, if the case started right there on the merits, there would have been plenty of time for discovery and all of that. But I just, based on all of those factors, the case should be heard on the merits. And
Did Macleery answer?
Macleery did not provide an answer. Well,
so you're claiming, you think that we should set aside a default judgment when the Macleery was properly served and he didn't answer?
Yes, Your Honor, because Ms. Macleery, he did provide, he helped provide responses to interrogatories. Mr. Macleery is a.
But he did not submit an answer as required under the rules of procedure.
Your Honor, he didn't because he thought he had met, he thought he was meeting all his obligations. He was told the company would take care of it, and.
Isn't that a dispute between him and the company?
Well, I mean, in some ways, but I think it's also a dispute for the courts to not allow someone to, you know, who was not intransigent, who thought they were doing everything they could, to.
Well, the summons told him he had 20 or 30 days or whatever to respond to the plan. I mean, it tells him who he has to respond to, and he didn't do that.
And Your Honor, I understand, and I think as a lawyer, I agree. It's how could someone not do that? But if, from his perspective as the manager of a local Steak Escape franchise, who was in his mind doing all he had to do and was told by the company that they would take care of it, which there had been a previous lawsuit, I think 10 years prior, and he had essentially done the same thing, and there were no issues with it. So I think from his perspective, he was doing all he could. He thought he was meeting his obligations. I think under the Parsons factors, even though he should have answered and didn't, the Parsons factors all weigh in setting aside the default.
I'll still give you a couple minutes, but I may give you a little extra time if you'd like it on the other side, but thanks.
May it please the court, I'm Rod Smith on behalf of Jason Hudson. This is a case about whether companies and individuals can be properly served with a complaint and a summons and sit on those documents for nearly 6 months before filing an answer and not be held responsible for their actions. Given the time constraints, I'm not going to go into great detail on the factual record and the procedural history. I'm going to rest on my brief on those issues. But there are 3 factual issues, Your Honors, and you've touched on some of them that I want to address that affect each of the issues that are before the court here today. And the first of those, Your Honor, and you asked this question, is whether Steak Escape had repeatedly represented not only to the Secretary of State, but to the general public that Mr. Macleery was the managing officer of that particular
What
state.
difference does that make when he was never served with a Steak Escape summons? I mean, they can represent that till the cows come home. Somebody's got to leave him a summons for Steak Escape for Steak Escape to be served. That didn't happen.
That was, in essence, that was refused.
No, not in essence. Not in essence. I mean, the only testimony we have is the affidavit of Macleery and his deposition. There is no contrary evidence. The only evidence is he says they're in Ohio or whatever. That's it. The process server decides not to leave it. I mean, that is not on Macleery. That's on the process server. It was never left. The only evidence we have to go by is what Macleery says. The process server, other than his returns of service, which don't go to this issue at all, never was deposed. There's no affidavits. There's no evidence for him. We got to accept what Macleery says is true in this regard, because that's it. And he says they're in Ohio, and he doesn't leave the summons. If they had left the summons and he says, well, I'm refusing it, I'd totally get your argument. But you have to leave the summons to serve the summons, don't you?
Well, it can be refused, Your Honor, as with, for instance, under the statute dealing with service for the Secretary of State, when a certified letter is delivered and it's refused, it's marked as refused.
Which isn't the case
that's still
here
acceptance
either,
of service.
Which didn't happen either here. But that, is there any law that says, is there any case law, and I apologize for sounding like I'm arguing with you, but is there any case law in West Virginia that says if I attempt personal service and let's just say I do say refuse it, I'm not taking that, and the process server says, well, okay, I guess there's nothing I can do, and goes away without serving him, is he served?
I'm not aware of any cases that say that, but I think these are unique facts. And I would respectfully request that the court would take into consideration that refusal is accepted under the statute. as service with respect to the Secretary of State. And in essence, that's what the court found here in its order on record, page 520, when, I think this is undisputed, through his testimony, that when the deputy clerk, or when the deputy sheriff asked, well, what about this complaint for stake escape? Then instead of accepting that, he said, I'm sorry. In essence, he said, you've got to take that somewhere else. That's not the right address. It's our position that Stake Escape of Kanawha City had the obligation to educate its designated officers and to accept service in a case like that.
Yeah, but again, you have no West Virginia authority that says if you don't leave a summons, you're served with the summons.
Not in that instance, but no, I don't, Your Honor.
Okay.
I don't have any case that
Fair
would
enough.
support that.
Fair enough.
However, he did receive a summons and a complaint that named Stake Escape as a defendant, that was delivered to an officer. It happened to have his name on it. It happened to be the one that was delivered to him, but he accepted service of that. That is an officer accepting service. He is serving as an agent of Stake Escape.
But he's not accepting it as Stake Escape then. He's accepting it as Josh Macleery. I mean, the summons say who it's for. Those are two different things.
And I understand your position regarding that, Your Honor. And I'm the only thing that I have to point to is the statute and refusal of service with respect to the statute.
Well, let's talk about service to the Secretary of State, because nobody cited this case, but there's a Burks versus Fast Check case. It's 217 West Virginia 291, and the syllabus point 2 under the corporate statute, and I understand this is the limited liability statute we're dealing with here, but it's the exact same language on the statute. I would certainly assume the Supreme Court would consider it the same. It says, service of process or notice upon a domestic corporation through the Secretary of State is insufficient when a registered or certified mailing of the process or notice is neither accepted nor refused by an agent or employee of the corporation. Here, it was neither accepted nor refused, so how do we have service through the mail?
Well, the only way that I could see service could be affected, and this is something that Judge Bailey honed in on, is did Stake Escape, as they're required to under the statute, did they designate a regular place of business for this, or regular office for this to be accepted? And in support, in response to Judge Bailey when she requested, give me some evidence that there's someone actually that's at that residence, what they provided was an affidavit from one of the owners that's very carefully crafted. If you read between the lines on that, what that owner says is, when I am in town, in other words, not out of town, doesn't indicate how often he's in town, but when he said, when I'm in town, I can accept service through certified mail.
Mail gets delivered whether you're in town or out of town.
Not necessarily with a certified letter that would require a signature.
That's true.
And so our position is, if Mr. Smallridge is at a residence out of town most of the time and happens to be in town at this office a few days out of the month, we don't know how much, he didn't indicate in the affidavit, then it's nothing more than a storefront that it can accept regular mail, but not necessarily certified mail.
Is there any law, is there any cases that support that?
Again, Your
That
Honor,
if you're not at that address enough, then this rule about refusal or accepting doesn't apply?
Your Honor, the only case that I know that even touches on the point, and it is admittedly before the statutory change, is Lee versus Gentlemen's Club, where a person had refused to accept service on a number of occasions, basically buried his head in the sand, refused to accept a number of mailings. The mailings didn't necessarily say refuse to accept service, but the court had found that that was sufficient for service in that case, and that was through the Secretary of State.
Did you cite that in your?
Yes, Your Honor, I did. And it's in the section on whether the default judgment should be overturned, because it also deals with the intransigency issue. And with that, Your Honor, shifting to the intransigency issue, I've got a few things to point out. As long as I'm talking about Lee versus Gentlemen's Club, one of the findings in that case was the court observed that when a company is aware of a lawsuit against it, or in that case, an injury regarding a potential lawsuit, they can't bury their head in the sand. And what that court observed is any reasonable company at that time is going to hire counsel and get the guidance they need to get them through that process. And in this case, what ended up happening is on September 8th, we have the area director and the director of operations that become aware that Steak Escape of Kanawha City is named as a defendant in a lawsuit. It's nearly 6 months before they get a lawyer. And it's our position that willful disregard for the situation that it was in and its failure to respond appropriately is intransigence in that case. And with respect to Mr. Macleery, in the briefing, petitioners would have this court believe that he was just a victim of circumstances. And he went to his company and said, "What do I do in this case? I'm not sure what to do." And the company said, "We'll take care of it." And that's the end of the story for him. That's not the end of the story. Something that we have cited in the record is an affidavit from my co-counsel, Bob Loria, and it is on pages 162 to 163 of the affidavit. And we took tremendous efforts to permit the defendants or the petitioners the opportunity to protect their interests. And on January 20th of 2023, he called the Steak Escape store. He wasn't obligated to do that, but he wanted to coordinate hearing dates for the damages hearing so they would have an opportunity to show up and protect their rights. Lo and behold, Mr. Macleery answers the phone. And when he answers the phone and Mr. Loria lets him know why he's calling, he responds, he's aware of the lawsuit and that the case was, and excuse this language, but quoting him, that it was bullshit. He went on to say he didn't care about the case or the hearing. Now, that kind of language and that kind of a statement and that kind of an overt statement about his feelings about this case, that shows that he actively disregarded his rights and ignored the complaint in this matter and didn't file the answer. Your Honor, I believe I am past my time.
You are, but I gave your colleague a little bit of extra time if you want to sum up.
I would like to sum up, Your Honor. We believe that service was effectuated on both of the defendants that are at issue here. We also strongly believe that both of the defendants buried their head in the sand and tactically avoided filing answers, tactically avoided this litigation the best that they could, which justified default judgment being entered against them and it not being set aside. With respect to the punitive damages, only a 3.25 to 1 ratio. That's well within the realm of the statute. And we believe that there is a sufficient basis for an award of punitive damages. And with respect to the attorney's fees, there's no challenges to the hourly rate or the work that we did, just that we did the work in response to the discovery that was ordered by the court. So we would respectfully request that the court affirm the rulings from below.
Thank you so much.
Thank you, Your Honors. It's my first time here today, so I appreciate the opportunity to be in front of you.
We're happy to
Thank
have you. Got to watch your language, though, sir.
I apologize for that.
Thank you. And because I committed to give 2 more minutes, please limit yourself to 2 minutes.
Yes, yes, Your Honor.
Thanks.
Your Honors, just briefly, with the understanding you already gave me more than 10 minutes probably initially, regarding just the point that was made by Mr. Smith about the call to Mr. Macleery, I would just note that that was after the default had already been entered. Not arguing with what is in Mr. Loria's specific affidavit, not getting into a dispute of facts on that, but bottom line is, as Mr. Macleery had testified in the course of this, he was under the impression that the company was taking care of it. And I think to the extent that wasn't done, then I think obviously there could be a dispute between him and the company. But I just think in the interest of justice, it's not. It doesn't seem right that an individual defendant who is the manager of the restaurant, who's named in the lawsuit, who believes the company is doing what it needs to do, has assisted the company in responding to interrogatories, is somehow intransigent and should be held to a default judgment of hundreds of thousands of dollars. And just briefly about some of the argument regarding being served with a complaint that names defendant, the Steak Escape of Kanawha City 2 LLC as a defendant, and that being sent to officials at the franchisor of this particular franchise. The West Virginia Supreme Court in 2020 in the Monster Tree Service case, it's 244 West Virginia, I think we cited the pinpoint is 366. It made it clear that actual notice of a lawsuit is not sufficient if the service rules have not been complied with. I would argue here, Your Honors, with this much questions about service, the case should be heard on the merits for both the petitioners, and it should be remanded back to the trial court should be reversed. It should be remanded back to the trial court.
So do you deny the fact that a service person tried to serve Mr. Macleery with Steak Escapes a complaint, and he said he couldn't take it because it needs to go out of state?
Your Honor,
despite the fact that he's listed on the Secretary of State's website as an officer.
Your Honor, what we have in the record is Mr. Macleery's testimony. I think based on that testimony, I'm not sure the process server tried to serve Steak Escape at that time. I think he asked a question, what about Steak Escape? Mr. Macleery, under no impression that he's an officer of the company that could accept service, said, oh, they're in Ohio. So from our perspective, the process server, I don't think there was a specific attempt to serve Steak Escape through Mr. Macleery that Mr. Macleery refused.
But they proffered it to him.
And
he said, I don't think I can take it.
Well, Your Honor, I'm not even I'm not going to concede that it was proffered to him. Based on the testimony, he handed him he said, are you Josh Macleery? Here's this one. What about Michael Hill? And he handed him that one and left it there. And then said, what about Steak Escape? And Mr. Macleery said, they're in Ohio. Now, the court can obviously interpret that how it wants. I would not say that was necessarily proffered to him or attempted to be handed to him or shoved in his hand and he throws it on the ground and refuses it. But the bottom line, and I think the most legally important parts, are the process server walked out of the restaurant with the summons and complaint and never left it there. Your Honors, that's all I have. Thank you very much for your time.
We understand your case and appreciate it, and the case will be submitted.
Thank you.
Thank you.
Please rise, remain standing while